by Learned Additional Motor Accident Claims Tribunal, Baden District CD. Full stop. Next para. Shri Sahu, PK Sahu, Learned Counsel for the
AP sir.
अरे सर
Sorry, sir.
Shri PK Sahu, Learned Counsel for the insurance company, submits that Learned Tribunal has overlooked the fact that the vehicle involved in accident was a pickup van bearing number UP 64H oblique 1373 full stop. Driver of the offending vehicle,
Section
namely
150 is a defense which is made available by
Rajkumar,
the statute
son
to
of
us,
Hari
which says
Narayan,
that if you do not
was
have a
having
valid
a
driving
license to
license,
drive a
then the
LMV,
insurance policy
but
will not
there
be
was
valid.
no endorsement
That
to
all we are
drive
with you, Mr.
in non-trans
There is no
I-
difficulty on
to
that.
drive
We
a
are not-
transport
So
commercial
therefore,
not
vehicle.
against you on
Full
that.
stop.
moment your lordship
Therefore, it is
says that
submitted
even
that
though
insurance company should have been
transport
exonerated,
vehicle
or there
will
should have
not
been
fit
an order
within
of pay and
the
recover.
contours
Next
of
paragraph.
LMV,
Shri
and if you have
AP
a
Shah,
license to
Learned
drive an
Counsel for
LMV,
the claimant,
you will not be
submits
authorized to drive
that
a transport
accident
vehicle.
took
But
place on
if
22/4/2008.
you have done so, the insurance policy
Full
will
stop.
still be valid.
Income of the
That would be
deceased
totally
is
contrary, my lord, to the
assessed
provision
at
of the
rupees
Act.
4,000. Deceased Martand Singh
That we have heard you.
is assessed at rupees 4,000 per
All right,
month,
let's
which is on the
Devrat,
lower
let us
side.
complete. Devrat, now we've
No
seen your
amount under the
submission.
head
Anything
of
else
future
that you want
prospects
to?
or under the head of and
Yes, we have
insufficient
seen
amounts have been
that.
awarded under the head of non-pecuniary compensation. Therefore, they be enhanced suitably. Next paragraph. After hearing learned counsel for the parties and going through the record, it is an admitted fact between the parties that the pickup van in question was a light motor vehicle as per the definition of LMV given in section 2 within bracket 21 of the Motor Vehicle Act.
But my lord, this in para 17 the court has finding that हमारे पास heavy vehicle का license था.
हैवी व्हीकल तो है ही नहीं
para
मैम वो।
17 लेकिन लाइसेंस हमारा heavy vehicle का भी था और हम
ये सवाल ही क्वेश्चन ही नहीं है। वो ये नहीं कह रहे कि हैवी व्हीकल थी और हैवी व्हीकल का लाइसेंस, उनका ये कहना है कि ये लाइट व्हीकल थी लेकिन आपके पास में कमर्शियल व्हीकल का एंडोर्समेंट नहीं था। समझिए, समझ के फिर बहस करिए। कितने साल होगा आपको वकालत करते हुए? 5 years में तो समझ जाना चाहिए। समझिए, समझ के
Medium goods vehicle shall mean any goods carriage other than LMV or HMV, whereas medium passenger motor vehicles means any public service vehicle or private service vehicle or educational institution bus other than a motorcycle, invalid carriage, LMV or HMV.
Made a minute. Thank you, Ms. Devrat.
Lordship, just one paragraph if you
Yes,
may.
we'll hear some. Yes.
Lord, para 39.
Para 39 of Devangan.
Devangan.
All right, we'll make a note of that.
Then your Lordship may kindly also make a note of para 55 and 58.
39 of Devangan.
Devangan.
Okay.
Lord, 39 actually summarizes everything.
Yes. Thank you, Ms.
Lordship.
Yes, thank you.
unladen weight of
Yes.
Actually summarizes everything.
May please, my lordship.
Yes.
My submission
Sorry.
will be, my lord.
gross vehicle weight of
The first part of
the
the
pickup
submission
van
is on the
did not
very
exceed
basic interpretation of the
7,500
definitions.
kilograms. Therefore, it will fall within the definition of a light motor vehicle. Full
Other
stop.
fold of the submission
Since
will be
kilograms.
on the point
The vehicle
that
in
the
question
impact
was
is already
LMV.
secured.
Therefore, in the light of the law laid down by Supreme Court in Mukund Devangan, पूरा citation
So,
दिया।
if my lord,
Question was LMV.
if my lord would please have a
Mere
fresh look
absence
on
of
the
endorsement to
aspect
drive a
of the
commercial vehicle
definition.
cannot be said to be a
If we have
fundamental
heard a
breach
view
of policy,
on the
so to
definition
exonerate the insurance
So
company.
we have a class of
Thus, in the
vehicles
light of the law laid
which
down by
consider weight.
Supreme Court in
We
Mukund
have a
Devangan,
definition of a light motor vehicle,
impugned
which is up to
award
7,500.
cannot be faulted with
We have a
and is
definition of
and therefore appeal filed by the insurance company deserves to be
passenger
dismissed
motor
and is
heavy
hereby
passenger
dismissed.
motor,
Next
which
one.
is in section
As
2
far
cross
as
16 and 2 cross
appeal
17,
filed by the
which
claimants
is
is
also
concerned,
exceeding 12,000 weight.
income of the
We
deceased
have
was
a
accepted by the
we have a
tribunal
class of
at rupees
medium
4,000 per month.
medium goods and
Full
passenger
stop.
vehicle, which
As
is
per the
defined in section 2 clause 23 and 2 clause 24.
Postmortem report.
There is no specification with respect to the light goods vehicle or
Exhibit.
light personal vehicle, light passenger vehicle. And my lordship,
Exhibit mark
all
नहीं
these
हुआ क्या इसमें?
definitions are very interconnected as far as the weight is concerned.
P3. age of the deceased was
Is the kind of vehicle
44 years.
and the name of vehicle.
Age of deceased
So if you have a bird's eye
Martand
view,
Singh was
as far as the
44 years,
definition is concerned,
comma. Therefore,
we have a class of vehicle
25% is to be
purely
added
on the
towards
basis
the
of
future
weight.
prospects. Calculator दीजिएगा please.
We have a kind of vehicle.
Therefore,
We have a class of vehicle
25%
and we have a name of vehicle.
towards the future prospects.
It is interesting to note that the name and kind of vehicle does not
Full stop.
specify
Since deceased
any
is
weighting.
survived by
There is no there is absolutely no mention
four
of weight
claimants,
in the
one
name and
fourth
kind
is
of
to be
vehicle.
deducted towards the living expenses of the
I will
deceased,
take for example, my lordship.
and thereafter
If you see section 2 plus 21, my
fourth
lordship,
is to be deducted
may
towards
please see
the
the act
living
now.
expenses of the
I will
deceased,
take for example, my lordship.
and thereafter
Have you formulated it, Kaushik?
My lord, I have
No, what you're saying,
my
have
written
you
submission
formulated
in a very short form, but I'm just expanding it, my lord.
full stop. Thus, the dependency of the family will come out to rupees 45,000 per annum. Full stop.
There is my lordship.
For a person aged about 44
But
years,
what I am
multiplier of
right now argument
14
is,
will be applicable.
beyond my written submission.
Yes, you got it.
When
Now tell
it
us,
is applied,
just
then
take it
total
forward.
pecuniary
You are saying
compensation
there
will come
are
out to
three
rupees
categories.
6,30,000.
Class
Full
of
stop.
vehicles
Over
based
and
on
above
weight.
which
Just give us which are
claimants
those
are
provisions.
entitled
Let me
to a
get
sum
some
of
key.
rupees 70,000 under the head of non-pecuniary compensation,
LMV
Just give us
up to 7,500.
just do the numbers.
and
yeah.
Yes, yes.
221 then?
claimant number 2 and 3
216
being
and
minors,
217.
being children of the deceased, are entitled to a sum of rupees 40,000 each under the head of loss of parental consortium,
All this definition
taking
are
total
very
compensation to
perfectly
rupees 7
interconnected,
lakhs
my lord.
80,000 in place of rupees 5 lakh 56,000
Non-weight.
awarded by
Yes,
learned claims
Kind of
tribunal.
vehicle without
Thus, there
reference
will
to
be
weight. That's the
addition to
second
the
thing.
tune of
Which is
rupees
that
2 lakhs
kind of vehicle without
24,000
reference to weight.
in favor of the claimants. This additional amount will also earn interest at the rate of 6% from the date of filing of the claim
There is a
petition till
police
the
vehicle,
date of actual payment.
243.
Other terms and conditions
There is a tractor,
of the award shall
244.
remain intact. Full stop. This additional amount, along with the accrued interest,
There is a
shall be
semi-trailer,
invested in the names of the
239.
claimant oblique claimants in a
There
monthly
is a
income
private
scheme of
service
Indian
vehicle,
Post Office for a period of 6
233.
years. In above terms, appeal is disposed of. कितनी
There
court
is
fees कितनी दी है
omnibus,
आपने?
229.
हैं?
There is motor car,
35 rupees
226.
कैसे हो जाएगा?
2004 में
There is a motor vehicle which is in
2004 की है.
226.
ओके ठीक.
Motor car
35 रुपीस
and
कैसे हो जाएगा?
2008 की है नहीं सॉरी
2008 की है भाई.
2008
अभी आपने बताया था 22/4/2008 की है. तो 1/4/2008 के बाद तो आपको कोर्ट फीस देनी पड़ेगी.
ultimately in all this
अभी आप दे दीजिए.
Kinds of vehicles
2,24,000 पे कोर्ट फीस दे दीजिए.
without reference to any weight.
शाम
There
तक
are
दे
kinds
दीजिएगा,
and
नहीं तो
names
इसको
of
मैं
vehicles
जीरो कर दूंगा अनाउंसमेंट
without
को.
reference to any weight.
शाम तक देना है आपको, ऑनलाइन
The
देकर
main benchmark
रसीद दे दीजिए, अमेंड कर
for
लीजिए.
identifying a class of vehicle is weight.
अदरवाइज दिस एनहांसमेंट विल बी जीरो. कल के लिए नहीं होगा.
After the definition provision,
मत करिए आप. शाम को 4:30 बजे तक दे दीजिए कोर्ट
weight
फीस.
of the vehicle.
नहीं तो जो है ये अनाउंसमेंट
Before that,
उसमें
my
लिख
lord,
दीजिएगा अगर कोर्ट
I
फीस
will
नहीं
just
देंगे.
point out by way of example that how
सारे वो
perfectly
जजमेंट्स जो मैंने लिखा है कोर्ट फीस मध्य प्रदेश में मैंडेटरी है, इट इज अ प्री कंडीशन, वो सब करके
Please see section 2 plus
और लिख
21.
के इसको कर दीजिएगा, नो अनाउंसमेंट
Inflict
कर
means a
दीजिएगा.
transport vehicle as defined in 247. Now the transport vehicle means a public service vehicle which is also defined as to
Issue
what public
notice
service
on
vehicle.
IA
And public service
2987/19
vehicle
on
also
payment
finds
of
mention in
PF per
217,
registered AD post
which is the heavy public
within 7
motor
days
vehicle.
returnable 4
And
weeks.
also
Call
finds
for the
mention
records.
in
And also an
medium
admission.
public
चलिए.
motor vehicle, medium passenger motor vehicle.
Returnable 4 weeks.
So it finds mention in a weight category between 7,500 to 12,000.
I'm praying kindly taken it after lunch man.
Motor vehicle.
आज फाइनल हियरिंग का
And
डे है.
also find mention in
Yeah.
weight category above 12,000.
12 p.m.
This is the heavy
नहीं
public
नहीं ऐसा
service
कुछ नहीं होता.
So much
या
likewise,
तो अभी या फिर एडजॉर्न
even
कर
the
देते हैं, स्टे वेकेट
Model
करके।
Education Institute bus.
12 PM में I am
Let's
prepared
take
model, but
the other
दो
example in the
केसों के
definition of
चीफ क्या
240.
नंबर आ रहे थे।
आने
So
दीजिए,
the
वहाँ किसी
education
और से बोल के
institute
बढ़वा
also
लीजिए।
find mention in 270, which is the heavy public service vehicle, and it also find mention in
वहाँ किसी और से बोल के बढ़वा
224,
लीजिए।
which
What
is
you are
This
saying
is a remand appeal man.
very, very clear
I prepared
distinction
this in
between
Oxford.
Where
vehicle
is the order
based on
of
weight
remand?
and vehicle
Annexure
based
model
on
T1.
name and
it is very clear distinction only on the basis of weight.
so they are all integrated. So what's the sequita?
So much like
Annexure, sorry,
the
P4.
significance is going to be the
P4 है।
justification
P4.
of the further provisions in the act.
Page number 22.
So as per the bird's eye view about the definition clauses, the definition is primarily a basic classification on the basis of weight. We have a
ठीक है, जाइए
classification
आप।
up to
आपकी अपील
7,500.
अलाउ कर
We
रहे
have a
हैं।
classification
जाइए,
from 7,000
देखिए अपना दूसरा
to
केस,
12,000,
देखिएगा श्री
and we have a classification above 12,000.
मकबूल खान for
The
the
interesting
appeal.
part is that
This appeal is filed
everything which is defined is
by the
already defined in the
defend
in the definition clause as well as
by
it's
the
mentioned in
defendant
the
being
clause.
aggrieved of। इसमें
So,
आपको क्यों एग्री होना
definition is
चाहिए? ये
also
ऑर्डर तो जो है रिमांड का आपके
and the
पक्ष
very
में है।
same
नहीं हमारे
type of
खिलाफ है ना
also find
मर्डर
mentioned in the
711 ट्रायल कोर्ट में हमने 711 की एप्लीकेशन लगाई तो ट्रायल कोर्ट ने हमारी एप्लीकेशन अलाउ कर दी, सूट डिसमिस कर दी हमारे खिलाफ। अगेंस्ट दैट ऑर्डर द
It is a medium.
रेस्पोंडेंट फाइल अपील।
So, मालूम है please read 223, for example.
अगेंस्ट दैट ऑर्डर द
Means any goods carriage, so much goods carriage is also find mentioned in 247. Means any
earlier
goods
he filed
carriage
a suit in the year
other
of
than
1981
light motor
man.
vehicle or heavy
Their suit was
goods
dismissed.
vehicle. So light motor vehicle is up to
7,000.
Earlier he filed a suit
and
in
heavy goods
1981
vehicle is 216 above.
By the defendant being
So
aggrieved
there is a very
of order
perfect
dated
categorization.
for judgment dated
And
16th
in
July
order
2019
to further expand the
passed by
example,
Lalit Second
let's
Additional
take
District
another
Judge
example
Jabalpur
from the
in
definition of light motor
RCA
vehicle.
12A oblique
Let's say
2012,
omnibus.
whereby appeal
So
filed by the
omnibus
plaintiff
finds mention in the
against
category
the
of light motor
orders
vehicle,
of
but omnibus also
trial
finds
court.
mention in 270.
judgment of trial
The
court
heavy passenger motor vehicle.
dated
And omnibus is
12/9/2012
in section just what
passed
exactly
by
is what
Learned
omnibus.
14th
It is
Civil Judge
defined in
Class 2
229.
in RCS 4A of 2010 within bracket Srimati Ashia Begum and others in
In the whole
RCS versus Abdul Salim and others
has nothing to do with the weight.
has been reversed and matter has been remanded to the trial court.
Weight is a
Full
separate
stop.
prosecution
It is submitted that a suit was filed by the plaintiff.
Because we
Defendants filed an application under Order
we
7
find a
Rule
very
11
common name
CPC.
in across the
Full
class
stop.
of
That application was allowed by the learned trial court and suit was dismissed, being barred by limitation. Full stop. Thereafter, plaintiff filed an appeal. In appeal,
example of motor car also.
learned
What are you doing?
first appellate court.
Good points you have raised.
Plaintiff filed an
That doesn't seem to be existing in the written
Directed
process.
that-
Formulated
Yes, I will definitely.
along with these sections and then give it.
I will then give it.
After taking
Because all these sections are very
return
much
statement
interconnected.
of the defendants,
You are put it down.
if the suit is found to be barred by limitation,
I will
then
do it, my lordship, and I will
appropriate
see.
action be
And
taken by the
therefore,
trial
the
court. Full stop. It is
definition has to be
submitted
seen in
that
a
this
bird's eye.
finding
Can't
is
be seen in
perverse.
isolation, the definition
Full
of a
stop.
transport vehicle
The
or
basic
the definition of
principle,
a light motor vehicle.
the thumb rule for allowing for finding is perverse.
Because
Dealing
every
with
word
an
mentioned
application
in the
under Order
definition of
7
light
Rule
motor
11
vehicle
is
already
that
defined
only plain averments are required to be
in
seen.
the other provision.
Full stop.
Give it to us.
When
Yes, my lord.
the trial court on the basis of the plain averments had found the suit to be barred by limitation, then there was no occasion for the
To understand
second additional district judge Jabalpur to have interfered with that order of dismissal of suit, directing the trial court to accept the written statement and thereafter decide the issue of limitation. Full stop. The impugned order being perverse and contrary to the law on the subject, comma, is hereby quashed. Appeal is allowed and disposed of.
it is the restriction for grant of learner license for certain for a certain vehicle. And Malaysia, what are those certain vehicles? is to be inferred because the word uses transport vehicle.
जी
Unless he held a driving license to drive a light motor vehicle for at least 1 year.
कहाँ है वो ऑर्डर जी
वो ट्रिपल
If a
सेवन जीरो ऑफ
person wants
2019
to
770
ऑफ 2019
निकालना भाई
So,
कहाँ है वो ऑर्डर डब्ल्यूपी
so basically, if a person wants to apply for a
क्या कहा है स्कोप लिमिटेड है
स्टैट्यूटरी नेचर है इसमें until unless they dispute the delay ये हमारा जो टाइम से जमा हुआ था they can substantiate the documents कि ये जो डिले हमने जो इसमें जो दिया है इनका चार्ट वो उस हिसाब से अगर डिले में कैलकुलेशन मिस्टेक है then only we can interfere otherwise the law says 7Q says may not it is statutory
very clear that
याद आ गया मेरे
so like the basic restriction with section 7
Seven also read it as exceeding 7,000.
Oh, because it has to get better because the word transport vehicle is already defined in section 2.
कोट किया है पैराग्राफ 2 of my reply
The appropriate interpretation in my submission will be
So you are trying to,
paragraph 8
therefore,
also I found
this section
Paragraph
will have
2
to be
of your reply.
recast.
paragraph 8
No
also
person shall be
2 and
granted
8
a
will
learner's
see.
license to
We
drive a
revise the
transport
legislature at
vehicle,
its wisdom.
brackets, which does not fall within the definition of a light motor vehicle, bracket
Very
complete,
clear terms
unless
behind
he
the
has held a
authority.
driving license to drive a light motor vehicle for at least 1 year. So we may be reading in some provisions into the statute.
so because the plain reading of this section says that a person is already having a
दीजिए बिना के ऑर्डर
So Devrat was saying that interpret 10 to E also in a different way.
आगे पीछे निकाला
So
करो
you're
यार
now
पेज
saying
वेस्ट
look,
मत
7
करो
also will have to be
नहीं ये
to be
फंक्शन आगे
slightly
पीछे
structured in interpretation.
person is going to apply, he's already having a driving
The
license.
only ground is they have not taken into consideration my defense.
So it is therefore
which
If your
defense
transport vehicle exceeds
I have submitted
7,500
reply to
weight,
that notice.
that this
That is not
prohibition in
that.
section 7 comes into it.
Yes, but if a person is applying for driving a transport vehicle above 7,500, because the word light motor vehicle is here. With the word transport vehicle above, so they have consciously put the word light motor vehicle here. Because the word light motor vehicle is here, so they've consciously put the word.
Only ground is that due to recession in business,
for 1 year.
recession in business is not a ground
this was
available
not deliberate. The delay is not.
उसमें कल के लिए रफ ड्राफ्ट बनाइएगा इसमें submits that this petition is filed on 2 grounds namely due to recession in business timely deposit could not be made out could not be timely deposit of
We will have to
contribution
rewrite
towards
all
employees
those
provident fund
provisions
could
of
not
the
be made out
statute now,
आपका recession कब से हो गया
including those for medical certificates, etc.
recession on
That those
papers
will apply to only those categories of transport vehicles where the weight exceeds 7,500.
that adequate opportunity of hearing was not granted, comma. Sri J. K. Pillai submits that this case is squarely covered by the earlier order of this court dated 6 July 2023, passed in WP number 7770 of 2019. Next paragraph. After hearing learned counsel for the parties and going through the record, no case for recession is made out. Petitioner has not enclosed copy of the balance sheets for the last years to point out the recession and loss in the business, full stop. Therefore, the ground of recession is not made out. Next paragraph. The provisions contained in the Employees Provident Fund पूरा एक्ट का नाम लिख लीजिएगा are statutory and mandatory.
Any
Therefore,
person who is not
petitioner's
disqualified under
case
section
being
4 of the
squarely
driving
covered with the judgment
and
of
not for
this
the time
court
being disqualified for
in under similar facts and circumstances in party around that shall apply mutatis mutandis to the facts of the
interestingly,
for 7Q recession will not restrict
हाँ?
for 7Q में discretion ही नहीं
हाँ
है
ठीक है
14 भी
तो उसमें ये भी लिख लीजिएगा
to
as
drive
per
a transport
section
vehicle
7Q
under
3 of
subsection
recession
1.
will also not come to their rescue.
Basically, subsection
Rescue
3
of the
is
petitioner.
taking you in a reverse gear to subsection
8
1.
नंबर भी वही है क्या
And subsection 1 is
that
taking you to
is
subsection 7.
different चलिए
Although 7Q order is under challenge, but the facts are
It
different.
talks about the application.
सही बताइए
Application.
Not as per
ऑर्डर रखो
page 13 of the
पेज 13
of the petition. As per page 13 of the
इसमें अगर सर एक हफ्ते वैसे तो मैंने रिप्लाई डिटेल दिया है
page 13 of
ये मैं और क्लेरिफाई कर देता हूँ कि इनके जो दोनों अमाउंट जमा है इनका कहना है 2 बार जमा हुआ है ये 2 बार नहीं है दोनों अलग अलग हेड में है तो अगर आप बोले
नहीं
तो
तो वो
क्लियर करता हूँ
आप लिख लेंगे ना यही प्लीज लिख लेंगे इसको क्यों एडजॉर्न क्यों कराना
ये 2 बार नहीं है दोनों अलग अलग हेड में है तो अगर आप बोले
But for the wage month
लिख लेंगे ना
September 17, as per this table, second last For the wage, they say that payment was made on 14th of September 2019.
Yes.
Second last. But the record speaks to the contrary, my lord. Payment was
बताइए, where
made
is
on
the
14th of page 33 may kindly be seen.
page 33? Yes.
Second last. But the record speaks to the contrary, my lord. Payment was
बताइए, where
made
is
on
the
14th of page 33 may kindly be seen. It's for wage month September 17. The payment was made on 14th of October 2017.
जी
And this is further substantiated by the bank account statement.
फिगर तो चेक कर लें 1 मिनट के लिए। यह है 4,84,000।
Substantiated by the bank
4,84,000।
Yes, ma'am.
यह है 4,00,000।
84,000.
4,84,000।
This is further substantiated by, my lord, the bank account statement, my lord, page 22.
पेज 22।
Yes, ma'am.
ठीक है, इनको देने ये क्लैरिफाई कर
This
लें।
is further
Clarify कर
substantiated
देते
by,
हैं कि
my
दोनों
lord, the
अलग-अलग
bank
हेड में
account
जमा हुए,
statement
same
on
amount
page
time to
22.
clarify the clarify his return on his request 7 days time is granted
10 दिन तक भोपाल का
2 weeks भोपाल कौन सा बहुत दूर है
नहीं
2 weeks time is granted list after 2 weeks चलिए 7 days time is granted 2 weeks जिसको वहाँ भिजवा देना उसको 2 weeks time is granted list after 2 weeks चलिए 7 days time is granted जिसको वहाँ भिजवा देना उसको 2 weeks time is
My lord,
list after 2 weeks
my lord, ये हमें फाइल किया my lord, कमिश्नर आयुक्त प्रतिकर my lord, उनके यहाँ से अवार्ड हुआ था हमारे अगेंस्ट में
जी
अवार्ड डेटेड है my lord 31/3/2022 my lord इसमें हमारे अगेंस्ट में जो अवार्ड हुआ my lord 6,47,866 रुपये
हाँ
पेज नंबर 20
यस
my lord उसको हमने उसमें लिखा हुआ था कि 50% 3,23,000 जमा कर दिए जाए
हाँ
तो my lord हमने 3 लाख रुपए जमा कर दिया है
फिर मैरिज पर बताइए ना क्या है
मेरिट पे ये है my lord कि ये जो मृतक है
हाँ
वो my
मैरिज
lord
पर बताइए ना क्या है
उनका कहना है कि हमारे यहाँ काम करता
हाँ
था वो काम करते समय वहाँ पे काम करता था और फिर अपनी खुद की जलाऊ लकड़ी के लिए उसको जरूरत पड़ी तो झाड़ पे चढ़ के लकड़ी काट रहा था
हाँ
तो गिर गया
अच्छा आपके यहाँ क्या काम होता है आपके यहाँ
सर वो खेती बाड़ी का काम करता था
जी जी
लेबर
हाँ, अच्छा आपके यहाँ क्या काम होता है आपके
और
यहाँ
मालोड वो अनमैरिड था उसके मदर
जी
फादर ने
हाँ
किया
ठीक है
और मालोड
लिखिएगा
जैसे ये गिरा था मालोड
नोटिस टू द रिस्पोंडेंट्स अभी नोटिस कहाँ हुए रिस्पोंडेंट्स को
उसके मदर फादर ने
on payment of PF per registered AD post within 7 days returnable 4 weeks in the meanwhile call for the record from the concerned traveler PF per registered AD
मालोड
post
स्टे एप्लीकेशन
within 7 days जवाब आने issue notice on वो भी कर दीजिएगा stay application as well as admission जवाब आने
माल ओला
issue notice on वो भी कर
Wait, please,
दीजिएगा
Lord.
stay application as well as
My lord, my first appeal was admitted for final hearing, finding it meritorious, my lord. But my application for stay was rejected by the learned court below, my lord, on 2 grounds. That no substantial injustice would be caused to me, my lord. And secondly, that I have
आप अपीयर हुए थे क्या
sir, मैं नहीं हुआ था, ये डिंडोरी का है। My lord,
आप 3912 के रिजेक्शन के खिलाफ आए हैं
सर वो डिंडोरी के थे वकील साहब उनने 41(5) में फाइल कर दी थी पर प्रेयर
ठीक है वही
जी जी
it is appeal to 3912
So my humble submission is that, my lord, my first appeal is already admitted. Nothing would survive to be decided when it reaches the final.
लेकिन आज साल भर बाद बचा क्या है ये ऑर्डर की डेट देख अरे भाई
सर अभी कुछ बचा है मतलब
14/6 नहीं उनको अपील डिसाइड करने के लिए बोल देते हैं 2-3 महीने में कुछ इससे तो है
My lord, I'll be highly obliged. Till then, status quo may kindly, my lord,
for your asking
then my humble submission is that, my lord, my lord knows the.
में कुछ हुआ नहीं आज हमारे पास स्टेटस नहीं है कि अपील का क्या क्या
सर मैं पता करके
नहीं पता करके आना चाहिए था आपको इसलिए आज कुछ है नहीं इस अपील पिटीशन में अगर इफ नॉट ऑलरेडी डिसाइडेड इट बी डिसाइडेड विद इन 2 months बस इससे ज्यादा कुछ नहीं ठीक है लिखिएगा श्री राजेश पंचोली अगर इफ प्लेस फॉर विड्रॉल ऑफ दिस पिटीशन within 2 months बस इससे ज्यादा कुछ नहीं इफ दिस कोर्ट डायरेक्ट्स द लर्नेड फर्स्ट एडिशनल डिस्ट्रिक्ट जज डिंडोरी to decide pending appeal number if this court directs the learned first additional district RCA number 24/22 within a period of 2 months from the date of receipt of certified copies if it is not already decided. Full stop. is directed that if the appeal is not already decided, as there was no stay from this High Court, then it be decided within period of 2 months from the date of receipt of certified copy of the on its own merits. This court has not expressed any. It be decided within period of 2 months from the date of receipt of certified copy of the on its own merits. This court has not expressed any. It be decided within period of 2 months from the date of receipt of certified copy of the on its own merits. क्या है P3?
Your Lordship, we have filed this petition seeking time-bound direction against the respondent authorities. We are an allotee and we have been granted relief under Real Estate Regulation and Development Act by the adjudicating officer way back in 2019.
Is High Court executing authority for the RERA?
No, Your Lordship, but we have filed we have already an RRC has already been issued by the regulatory authority in favor of the allotee.
We have filed the reply, Your Lordship. Important fact has come because of the stay order granted by National Company Law Tribunal. White order dated 5/8/22. The RRC could not be issued.
RRC could not be executed.
Could not be executed.
उसके बाद right में क्या करेंगे?
Your Lordship, it is a faulty finding that they are stating here. That particular order where moratorium was granted was of 5 August 2022. Thereafter, the Real Estate Regulatory Authority in that matter went for appeal under NCLAT, and an order dated 8/9/2022 is already in force, whereby that order dated 5/8/2022 has already been stayed by the NCLAT. Your Lordship,
to bring those orders on record.
yes, Your Lordship. Your Lordship, if I may be permitted to submit.
हाँ दे रहे हैं ना आपको.
So, as far as
disposal कर रहे हैं.
definition of section 10,
Shri Amit Sharma, learned counsel for this
10 to D and 10 to E is
grievance of the
concerned, it also has to be
petitioner
read
that the
considering a
real
very
estate
holistic view of the definition.
regulatory authority
It is not
Madhya
a very
Pradesh
short
Bhopal
formation. The much
issued
other
a
part is
revenue
with respect to
recovery
the rules.
certificate
So, because
in favor of
This
the
formulaic, what
petitioner
you are saying in the
Anjali
rules, what you have to say on the
Patwardhan
rules?
and
as far as the
against
syllabus part
the
is concerned,
respondents AG8 Ventures Private Limited.
What is your
they
formulation?
no syllabus for
On
transport.
22nd
Only for
July
light motor
2020,
vehicle and medium
but
oblique heavy
same has not been
motor vehicle.
executed.
There is no
Next paragraph.
syllabus for
Shri
transport.
Amit Sharma submits that
Therefore, to
NCLT
say that there is a different
passed an
syllabus
order
which not in
dated
consonance with
5/8
Rule 31J. Rule
5/8/2022.
5/8/2022 restraining the
Rule 31J.
5/8/22
Actually, Master, in my written submission, I only just want to point out because
whereby a
because my lord
proposal
is
was
not impact.
filed for
Yes,
liquidation of the
If my lord
corporate
will,
debtor,
please see my written
that is the
submission.
person against whom RRC is to be executed. Next paragraph.
The
Ms.
concept
Tanisha
of
Ajmani submits
third-party
that
insurance
this
is introduced as per
plea
chapter
of the
11 of the
respondent
Act.
collector is half-baked. Thereafter, while order
It was
dated
introduced in the
39/2022.
by way of
30th
amendment Act
September
54.
2022,
And if my lord will,
NCLAT,
please
Yes,
see
Your Lordship.
page number 3 of my written
कहाँ है वो
submission.
order दिखाइए?
Your Lordship. Your Lordship, we tried to file this, but since the petitioners,
As per section 49, my lordship,
Principal Bench,
which
New
falls
Delhi,
under
we tried to file
chapter
this, but
11.
since
in
the
company
petitioners
appeal
object
within
of the
bracket
amendment
80
is
bracket close, another bracket insolvency bracket close,
page
NO
number 3, my lordship.
W
My point
sorry
number 5.
1172 and 1173 of
Its
2022.
main object is to provide the adequate compensation to victim of the road accident without
At
going
the
through the long drawn procedure.
instance of Real Estate Regulatory Authority has
has
directed that
there are two kind of insurance, my lord. One is a statutory one is a statutory insurance, which is as per my lord, chapter 11 of the Act. They must have to have the my lord, statutory. They need need to have the statutory insurance, my lordship. It is a
Has
compulsory.
directed
It is a
stay
compulsory
of the
third
order,
party insurance as per
stay
the
of
act.
the, stay
It
on
is
the
not a contractual insurance, my lordship,
in
where we take a comprehensive
2022.
policy.
The LEB
For my lordship,
taken by the collector
it is
Bhopal
statutory
to not
insurance.
to execute the order is not available.
And
Next
thereafter,
para.
my lordship,
Copy of the order
chapter 11 was
dated
further amended
30/9/2022
by way
is
of an
taken on
amendment act
record.
of 32
Next
of
para.
2019.
Looking to the
And
fact
as
that
per clause
there
2
is
of the
stay
statement
on
of
the
object and reason,
orders of
the main purpose was,
NCLT
my lordship, to basically
by
further,
the
my lord, quantify the
National
loss
Company
of the
Law
family
Appellate
by
Tribunal.
losing its breadwinner.
Orders of
It
as
is very
discussed
categorically
above,
mentioned the object
Collector
of the
Bhopal shall be obliged to and shall execute the RRC within 30 days of receipt of certified copy of the
I will
order
do that, my
under
lordship.
intimation to the registry of the High Court. And shall
Obliged or
execute the
not.
And my
RRC
lord, for a
within
simple
30
reason
days
that
of receipt of
it
certified
is a
copy of
basic
the
law
order under intimation
that the
to the
concept of
registry of the High
insurance
Court.
is the concept of indemnity. So pain recover, my
Shri
lordship.
Apachuna.
Page number
Sanjay
7
Asati
is the
prays for
pain recover, my
withdrawal of
lordship,
this.
because this furnishing judgment
Dhananjay
is a
Asati
good law
prays for withdrawal of this miscellaneous
as on date.
petition.
And
Prayer is not
only
opposed
the
by Shri
part
J.L.
which is, my
Soni
lordship,
for the caveat.
I am worried,
Accordingly,
my lordship, is that
miscellaneous petition is dismissed as withdrawn.
because
Prayer is
settled
not
as on
opposed
date,
by
but
Shri
part
J.L.
3 was 150 defense which they are talking about is one subject matter of trial.
Miscellaneous petition is
They can
dismissed
take a defense, it is a valid defense, but the defense has to be proved.
My lord, in this case, my lord, the last date of hearing state have directed
What we
to
need
seek
to
a stay, my
understand, my
lord.
lordship,
The mere fact of the case is that, my
most
lord,
of the MSCT matter, my lordship,
petitioner has
victims
taken
are
some
under court.
loan
And it's
from
therefore
respondent
the
number 4
amendment of
Sahkari
1994 and
Samiti, my lord,
2019 is
for
in a way of
बीज और
beneficial
खाद के लिए दिया था.
and accordingly the
After that, my lord,
total
when in year
why not apply
2019, my lord, state government
क्या instructions हैं आपको?
Your Lordship, last time it was ordered on 10/5/2023, before vacation.
Total vacation में instructions नहीं आते.
It's the name of Anuj
ऐसा
Bhandari,
है
my
क्या?
lord, 501.1. Certain submissions.
Total vacation में instructions नहीं आते.
It's the name of Anuj
ऐसा
Bhandari, my
है
lord,
क्या?
501.1. Certain submissions.
देखिएगा. This petition, Shri Shyam Yadav, learned counsel for the petitioner. Shri Amit Sharma, learned government advocate for respondent number 1. Full stop. Petitioner's only grievance is in terms of the earlier order dated 10/5/2023. Instructions have not been placed on record by the counsel for the state. Next. Petitioner's only grievance is that they have made a complaint to respondent number 1 in regard to conduct of respondent number 2, 3, and 4, and prayer is and this backdrop prayer is made to direct respondent number 1 to take appropriate steps upon the complaint of the petitioner made against the bank management in the interest of justice. This innocuous prayer is not opposed by Shri Amit Sharma. This petition can be disposed of with the direction to respondent number 1 that in case they have already not taken a decision on the complaint of the petitioner, annexure, complaint is annexure, annexure P5, then petitioner shall file copy of the complaint afresh within 15 days from today, and they shall take appropriate action on the complaint in accordance with law within further period of 3 months under intimation to the petitioner. This court has not expressed any opinion on the merits. Within further period of 3 months under intimation to the petitioner. This court has not expressed
This petition is against annexure P12, whereby the CO, whereby my lord the Jila Panchayat CO had directed the Janpat Panchayat CO to lodge FIR against the petitioner. Now, my lord, FIR, I am a secretary, my lord. Now, my lord, after filing of this petition, FIR has also been lodged, my lord.
बच्चा क्या इसमें फिर क्वेश्चन के लिए आइएगा अगली पिटीशन लगा के
इसी में अमेंड कर देंगे
नहीं इसी में कैसे अमेंड पूरा फॉर्मेट अलग है 482 में आइएगा क्वेश्चन के लिए
we are challenging this petition, my lord. What my grounds are, my lord. This is second FIR, direction of second FIR.
That is, I'm not going into the merits of the case. Second FIR, third FIR. You have a right to seek quashment of that FIR. You file appropriate proceedings.
Only one submission. By annexure 39, my lord, they have in the year 2020 on the basis of same inquiry report, they have directed the authorities to lodge FIR.
क्रिमिनल लॉ में क्या प्रावधान है? 2 FIR एक ही उस पे हो सकती है अपराध के लिए?
मैं एक पॉइंट मतलब बता दूं, उस पे अगेंस्ट दैट ऑर्डर वी फाइल्ड a writ petition before this court. This court has directed, my lord, that till notices have been issued and it has been directed that no coercive action shall be taken against the petitioner in pursuance of that order, and that matter is still pending. And now again they have directed to lodge FIR.
तो उसकी आपका ग्राउंड होगा ना क्वेश्चन के लिए, आप फाइल करिए पिटीशन क्वेश्चन के लिए। अभी तो आप उनको रोकने के लिए आए थे। हाँ, FIR has been filed, therefore this petition is rendered infructuous. You will be at liberty to challenge lodging of second FIR on the same subject matter. Who stops you from filing a petition? नित्यानंद मिश्रा, learned counsel for the petitioner.
और इसका कंटेम्प्ट हो गया सर, ये तो
Fairly
contempt फाइल
submits.
कर सकते हैं।
अब वो तो हम एडवाइस सुनना देंगे। नित्यानंद मिश्रा, learned counsel for the petitioner. आप लोग नाराज हो जाएंगे अगर हमने एडवाइस देना चालू कर दिया। वो तो हम एडवाइस सुनना देंगे। क्या लिखा? आप लोग नाराज हो जाएंगे अगर हमने एडवाइस देना चालू। Submits that this petition is filed for quashing directions contained in Annexure P12. This petition is filed issued by the additional collector within bracket development and prescribed authority Jila Panchayat Anuppur to the Chief Executive Officer Janpat Panchayat Jathari to lodge FIR. It is submitted, it is fairly submitted that in pursuance of the said order, FIR is already lodged. Full stop. Petitioner wants to challenge lodging of second FIR on the same subject matter. Full stop. That is the prerogative of the petitioner. He is free to file appropriate petition on appropriate grounds in that behalf. For the present, as far as this petition is concerned, since the FIR has already been lodged, relief claimed in the petition to restrain the respondents to lodge a FIR has become infructuous. Therefore, petition is dismissed as withdrawn with the aforesaid liberty.
सेकंड FIR का नहीं है सर।
हाँ, लिख तो दिया, सेकंड FIR लिख दिया।
नहीं तो उस बार FIR नहीं हो पाई थी, इसलिए
तो सेकंड पे कैसे हो जाएगी?
पिछली बार
सेकंड हटा दीजिएगा, सिर्फ FIR लिखिएगा। चलिए, FIR लिख दिया।
नहीं तो उस बार FIR नहीं हो पाई थी, इसलिए
सेकंड पे कैसे? जो बहस करते हैं वकील साहब, वो जो है तथ्यात्मक होना चाहिए। आपने 3 बार कहा सेकंड FIR।
नहीं, ऑर्डर ऑफ लॉजिंग सेकंड,
ऑर्डर ऑफ लॉजिंग से नहीं होता है।
उसमें उन्होंने पिछली बार भी FIR
जाके वहाँ बताइएगा। आपने 3 बार कहा सेकंड FIR।
नहीं, ऑर्डर ऑफ लॉजिंग सेकंड,
ऑर्डर ऑफ लॉजिंग से नहीं होता है।
उसमें उन्होंने पिछली बार भी FIR
जाके वहाँ बताइएगा। 3 बार कहा सेकंड FIR।
Actually, this is death case.
हाँ, इनकी अपील किस ग्राउंड पर है? शुक्ला जी, आपकी अपील क्यों आई है?
Death case.
नहीं, आप तो इधर आएंगे ना। अपील किस ग्राउंड पर?
अपीलांट भी है ना सर,
अच्छा,
बीच में आएंगे और रिस्पोंडेंट की तरफ से।
जी जी जी,
ये सर जो एनहांसमेंट वाली है,
बताइए बताइए। आप तो एनहेंसमेंट में हैं। ये
इसमें सब कोर्ट फीस अभी तक पे
नहीं होगी तो इनको अमाउंट नहीं मिलेगा। जी, मेरे कोर्ट का बहुत सेटल्ड है। 4:30 बजे तक कोर्ट फीस पे हो जाएगी, दे देंगे तो एनहेंसमेंट मिलेगा, नहीं तो वो कैलकुलेट होकर 0 हो जाएगा। 4:30 में आपने क्लियर कर दिए हो जाएगी जी, दे देंगे तो एनहेंसमेंट मिलेगा। हाँ, तिवारी जी, पहले इनको तो सुन लें, इनकी अपील। चलिए, थैंक यू। हाँ, बताइए आशीष। हाँ, तो देखिए, अरे अभी तो
मैंने ये नहीं कहा सर, कहा ये कि पहले अपील को देख लें, कुछ बचता भी है।
अच्छा, चलिए, हाँ बताइए। अरे अभी तो आप कोर्ट फीस देंगे तब तो इतनी मेहनत करें। 30 रुपए में नहीं सुनेंगे आपकी कोर्ट फीस। अच्छा, चलिए, अगर एनहेंसमेंट होगा, यू विल पे कोर्ट फीस ड्यूरिंग द कोर्स ऑफ द डे। कोर्ट फीस देंगे तब तो इतनी मेहनत करें। एंड ये डिफेक्ट क्यों नहीं लगता है? रजिस्ट्री को बोलिए फिर सब में जितनों में कोर्ट फीस नहीं आती है, ये सब अपील डिफेक्ट में लगा के खारिज करें इनको। यार वकील साहब लोग कोर्ट फीस लेके रख लेते हैं और उसके बाद में कोर्ट फीस नहीं आती है, ये सब अपील डिफेक्ट में लगा के खारिज करें इनको। हाँ, वकील साहब लोग कोर्ट फीस
पहली जो उसकी FIR थी, FIR वन बाय द वाइफ ऑफ द
जी,
उसकी वाइफ ने FIR की थी।
हाँ, क्या है पढ़िए,
करती है कि नहीं वो FIR
पढ़िएगा
उसी के बयान से
जी।
पॉलिसी में नहीं सर,
1.1. I filed my written submission trying to formulate the point my lord just referred to.
उसकी फोटो खींच लीजिएगा आप।
पॉलिसी में नहीं सर, नहीं वो
In the name of Anuj Bhandari, my lord has yes, my lord just. My lord, my first submission is I won't go to the extent of saying that this reference has lost its meaning or it has become infructuous. But with passage of time, my lord, Mukundan was decided in
Miscellaneous Class D
2017.
vehicles liability only.
6 years since, my lord, much water has flown and things have now aligned in accordance with Mukundan. There have been two subsequent amendments
Naveen Baraskar,
which
insured's
are
name.
before my lords. Mukundan was not interpreting those amendments. What Mukund Devgan was
28/7/2010
interpreting
से
was
27/7/2011
1994
तक वैलिड है.
as it stood then.
डेट ऑफ
Reference
एक्सीडेंट
here
क्या
is
है?
Mukundan was wrongly decided. So if my lord is to
जी?
check whether Mukundan is rightly or wrongly decided, you have to turn back the wheel of time, go back to 2017 and check 94 onwards, which doesn't make sense because now the provisions, relevant provision has changed. In line with Mukundan, Mukundan said exclude LMV from transport vehicle, make it its own category. This honorable court says that government does the same. I'll show how and when. And now can you say no, it doesn't mean what Mukundan says?
Steps have been taken after this to reaffirm. The Parliament has affirmed Mukundan makes this matter.
Not Parliament, but I'll show that. My lord, मैं हाथ form form 4 as it stood when
सर उसकी FIR को पहले देखना पड़ेगा, FIR उसी ने लाइव की.
Is it near submission?
No, my lord, it's not part of my submission. It's there in Mr. Dave's submission, page 75. My lord, I have. This is Mukundan has Mukund Devgan has taken the excerpt of the form as it stood in prior to 1994. From 89 to actually 2001, the form was introduced later. Amendment came in 94.
So this form 75 held the field between?
Form 4 was page 75. Form 4 was in existence from 1989 till 2000.
Held the field between?
One. Form 4
खुदाई कर रहा था,
what did
यही
it
आया,
say?
पीछे से ट्रैक्टर ने मारा है.
Page 75
ट्राली का है जो है, ट्राली का बीमा ही नहीं
of
था.
Mr. Dave's
खुदाई कर
written
रहा था,
submission.
यही आया, पीछे से ट्रैक्टर.
ट्राली का बीमा नहीं था.
ट्रॉली तो अटैच होती है ट्रैक्टर से, हम ऑलरेडी कह चुके हैं.
दोनों का सेपरेट नंबर रहता है, दोनों का बीमा अलग अलग है. यही तो गवाह कह के गया.
ट्रॉली तो
This
अटैच
is form 4.
ट्रैक्टर along with
Look at the
ट्राली.
category
अब दूसरा उसमें क्वेश्चन था वो ट्रैक्टर along with ट्राली, ये ट्रांसपोर्ट भी. अब उसको परमिट भी चाहिए, रजिस्ट्रेशन भी चाहिए.
medium goods vehicle, medium passenger motor vehicle,
बताइए
heavy goods
फिर आपने
vehicle,
क्या
heavy
एविडेंस
passenger
लीड
motor
करी? चलिए
vehicle.
आप ही की बात मानेंगे. क्या एविडेंस लीड करी आपने
Yes,
इंश्योरेंस
so
कंपनी
no
ने?
reference of transport vehicle
परमिट
based
था,
strictly on
लीज
weight.
था और
This will also lead to my next argument. I'll cover that later. Strictly on based for good 12 years when the act came into force.
कुमार जैन अभी तक साथी है.
Strictly on based
Categories, there is no reference.
निर्मल कुमार
no
जैन.
reference to transport vehicle.
इसमें का ट्राली का बीमा नहीं है.
My lord, I have this.
एवं
Light
किसी
motor
ये बात
vehicle.
सही है कि पता डी एक
Medium
में
goods
एक
vehicle.
ड्राइवर और एक सवारी.
So categorization for grant of
ट्राली का बीमा हमने नहीं किया.
basis on
ड्राइवर की रिस्क कवर है, ट्रॉली का बीमा नहीं, किसी भी अन्य व्यक्ति का बीमा कवर नहीं है.
next page, my
अब
lord.
वह कहता है कि गलती से लिख दिया है,
This is-
ऐसा कहना गलत है कि ट्रॉली ट्रैक्टर का पार्ट होता है. हमारी कंपनी में ट्रैक्टर केवल घटना दिनांक को बीमित था.
Next page, my
अब
lord.
वह कहता है कि
So the
गलती से
practice
लिख दिया है,
changed in
ऐसा कहना
2001
ट्रॉली ट्रैक्टर का
and
ट्रैक्टर
now
एंड ट्राली सेपरेटली डिफाइंड है, लाठी मोटर व्हीकल है.
हाँ ठीक है, बताइए कहाँ
it says motorcycle, invalid carriage, light motor vehicle, transport vehicle, and medium passenger motor vehicle.
उसके बाद परमिट भी नहीं.
कहाँ है आपने कहाँ एविडेंस लीड करी? आपको किसने रोका था कहने के लिए कि परमिट की जरूरत पड़ेगी अगर ट्रॉली के साथ ट्रैक्टर है?
ठीक है,
The mirrored forms mirrored.
आप जो बहस कर रहे हैं उसको सब्सटेंशिएट तो करिए.
Permit की जरूरत form also changed. And therefore, my lord, I'll submit that.
वैलिडिटी टू ट्राली का इंश्योरेंस ही नहीं है.
वो तो ठीक है, मान लिया.
वो मान ली तो अगर वो ट्राली से गिर के मरा है,
गिर के नहीं मरा है.
हाँ तो
ट्रॉली रिवर्स कर रहा था, ट्रैक्टर रिवर्स कर रहा था, ट्रॉली की चपेट में आ गया.
केस ये बनाया है कि वो रिवर्स
And
करते
see
समय
what was
दीवार
behind
ट्राली
it.
की,
What did it replace?
अब उसके तो ट्राली से उसका एक्सीडेंट हुआ.
Now, my lord, may have my written
Accident नहीं हुआ.
submission and
अच्छा,
my lord may come to page 16. 15 first. So these two forms were interpreted by Mukund.
वो ट्रांसपोर्ट व्हीकल माना जाएगा, ट्रैक्टर along with
You have
ट्राली.
to read down
ऐसा
the
कहा है,
transport vehicle.
थोड़ा बता दीजिए ना इसको. ये बात बता दीजिए.
Pursuant to that, in 2018, Mukund Devgan is 2017.
बता दीजिए ना इसको. ये बात बता दीजिए.
Submission gives the exact data.
ये लाठी भी जजमेंट
3rd July 2017, my lord. very first line rather.
नटवर पारिक वर्सेस स्टेट ऑफ
That is the
कर्नाटका
date
कॉपी
of
दे
decision.
दीजिए
जी
Pursuant
2006
to which,
का
my lord, I have
ACJ
now
है
my
2006 का
written submission,
हाँ
page 15. This is the
ये
notification
वॉल्यूम 2 पेज
issued
1
by
2006
Ministry of
वॉल्यूम 2
Transport and Highway.
जजमेंट रखा हूँ
ECJ
जी
हाँ वन ठीक है चलिए और 2006
उसमें
But the
सुप्रीम कोर्ट
third
ने कह दिया
paragraph
कि
I'll
वो
read
उसको परमिट
of the
चाहिए
notification main body. And whereas copies of the
सुप्रीम कोर्ट
said
का जजमेंट
gazette
है
were
ये
made available to public on 29th August 2017, a draft notification was issued. And whereas no objections and suggestions have been received from public in respect of the said draft. Now let's go to the form. This was in 2018, 20th March 18. This is the form which changed. What are the categories? Page 16, my lord, class of vehicles.
What is form 2 now, is it?
Yes, form 2. It is earlier it was form 4 and 6. 4 was for application, 6 was for giving license. Now it has merged into form 2. Yes, form 2. It is earlier it was form 4 and 6. 4 was for application, 6 was for giving license. Now it has merged into form 2. Yes, form 2. It is earlier it was. My lord, has it page 16?
Yes.
Yes. So categories are motorcycle, two of them. Motorcycle and e-rickshaw, my lord, I'll deal separately. Let's just focus on light motor vehicle as non-transport.
7 में लिखा है
It was never there. Let's just focus on light motor vehicle. Light motor vehicle as non-transport vehicle.
जी
Invalid carriage.
फैक्ट्स
Light
पढ़
motor
लीजिएगा
vehicle as
पहले they were
transport vehicle.
transporters and transporters were required to have a permit to transport
Goods or
heavy
passenger
goods like
vehicle as
transformers
transport.
चलिए ये आपकी पॉलिसी किस चीज की है
2000
पांच कॉपी
form. It was just transport.
वो
So the
देखना
confusion whether it includes
ये
LNG or not.
जो
Today
बोल
before
दूंगा
my lord, this is what is to be interpreted.
चलिए और बताइए इनकम आपकी बढ़ जाएगी 3000 की जगह 4125 हो जाएगी
There's no
आप
scope
कोर्ट फीस दे दीजिए शाम को 4145
There's
हो
scope for
जाएगी
interpretation.
फ्यूचर प्रोस्पेक्ट लग जाएगा उस हिसाब से कंपनसेशन कैलकुलेट हो जाएगा
Non-transport and transport.
Correct. And medium or heavy vehicle as transport vehicle. This is further change. This is further change.
But this indicates
एफआईआर
that
में
you may have a light motor
एफआईआर में
vehicle
लिखा है कि
license,
वो
but you
मुरम
can't
खोद
use
रहा
it
था
for a
पीछे से
transport
ट्रैक्टर
vehicle.
ट्रॉली ने मार
Now,
दिया
transport. So you have a two
TP
kind of vehicle.
अगर
Not
वो
on the
पैसेंजर होता तो आपकी
on the
बात सही
basis of
लेकिन परमिट नहीं है सर
NT.
परमिट की जरूरत ही नहीं है आई विल होल्ड इट
Right, not on the basis of
हाँ इसीलिए मैं आपकी बात देख लिया ये
So
जजमेंट भी
it
देख
was
लिया
by, so it
I'll
means
write
that
it.
transport vehicle
I'll
were
dictate
always
it in the
included
chamber.
in LNV.
इसीलिए मैं आपकी
Let it take it otherwise. So when I today the license in my pocket doesn't say NT or T. It is in 2018. Take it otherwise. The licenses which were being shown today originates this concept.
कोर्ट फीस शाम तक देंगे तो ठीक
They
है
were giving. I don't know. But this concept originated in 2018.
उनको बता
Prior
दिए
to
कैलकुलेट
that,
कर
I
लीजिएगा
was only getting
4145
LNV
प्लस फ्यूचर
license,
प्रोस्पेक्ट
which always included transport vehicle. This concept originated.
कैलकुलेट करो मैं कैलकुलेट करके दे दूं तो आप ये कोर्ट फीस भी भर दें सब वही कर दूं
शुक्ला जी से कोर्ट फीस भी भरवा लो फिर तो क्या हो जाए
करो मैं कैलकुलेट मैं भर दूं एक्सपीरियंस भर देंगे
हाँ वो बात तो एक ही है शुक्ला जी से कोर्ट फीस भी भरवा लो फिर तो क्या
Yes, there was a bifurcation.
two judgments.
You need two different licenses. To drive a LNV for transport,
15.1 my lord.
LNT, and to drive a non-transport, you need
15 में लिखिएगा
LNT.
श्री
Meaning
आशीष तिवारी
LNT
for the
does not
petitioner
exclude
for the appellant
transport
श्री
vehicle.
सुरेश राज
What
for
has
the
been
respondent number
argued
3
Can we interpret the
15.1
provisions
में
of the
लिखिएगा
act on
श्री
the
डी
basis
एन
of the
शुक्ला
form?
for the appellant श्री
It's more
नासिरी
of a practice.
Yash Nasiri.
यश नासिरी for the respondent क्या लिखा है इसमें
The trolley is
Well, a
part of
question
tractor.
here.
हाँ वो तो
that's
मैं भी
an
होल्ड कर
important
चुका हूँ
question.
Only
Devangan is right, that you can't use the form to interpret the
As
act.
Justice Chinapareddy said, it's like the tail wagging the dog.
तकलीफ है
Correct.
It's the dog wagging the tail.
I have always held the belief that you can't even use the rules to interpret the act because
There's an application for
otherwise that would
intervention.
enable
The
the central
complainant,
government
my
to
lord,
change
who
the meaning of the act
files a
if you were
complaint,
to
my
use
lord,
the
he comes
rules.
as an intervener. And in fact, his, whatever he had to say, that was taken care of by the respondents on the basis whereof the impeachment order takes his birth, my lords. And in fact, his, the matter needs to be finally heard also.
Vacating stay application is also.
सुनाइए
It has to be heard
ना
finally.
सुनाइए सुनाइए
And in fact, his, The matter needs to be finally. Can I submit, please?
Please.
Well, the order which comes under challenge is of 8/1/2018, P21 at page 112. But before I take my lords through the impugned order, may I take my lords by prayer clause, my lords, please. This comes, my lord, at page 21. Before I take my lords
Page
through the
21, yes.
impugned order, may I take my lords by prayer clause, my lords, please. This comes, my lord, at page 21. Before I take my lords
Page
through the
21.
impugned order, am I there with my lords? To issue appropriate writs orders for setting aside the impugned order 8/1/2018 P21. Am I there with my lords? Two is to issue appropriate writ orders directing respondent number 4 to consider petitioner's application for modification of permission dated 7/10/2016 in accordance with the directions of the Apex Court contained in the order dated 12/8/13 passed in the writ petition so-and-so T.N. Godhavardhan versus Union of India. My lords, let's have a perusal, my lord, of the order which comes under challenge. It is at page 112. My lords, let's have a perusal, my lord, of the order which comes under challenge. It is at page 112.
Yes.
It reads like this. उपरोक्त विषय अंतर्गत जन सुनवाई अंतर्गत जांच कार्यवाही जाकर पाया गया कि आपके द्वारा सारा सीईओ द्वारा दी गई पुनर्निर्माण स्वीकृति के अतिरिक्त तथा विपरीत कार्य कर लिया गया है, जो कि माननीय न्यायालय द्वारा दिए गए दिशा निर्देशों का उल्लंघन है। साथ ही सारा सीईओ द्वारा दिए गए पत्र क्रमांक 269 दिनांक 12/5/17 द्वारा दिए गए आदेश का भी आपके द्वारा उल्लंघन किया गया। अतएव एतद द्वारा आपको विषय अंतर्गत में दिया गया समस्त अवैध निर्माण पत्र प्राप्ति से 1 सप्ताह की समय अवधि में स्वयं हटवाए जाने हेतु आदेशित किया जाता है। अन्यथा की स्थिति में आपका संपूर्ण अवैध निर्माण शासकीय व्यय पर हटवाया जाकर व्यय की पूर्ति आपसे की जाएगी, जिसका समस्त जवाबदारी आपकी होगी। If my lord is a perusal of this order, why do we say it bad? Because it does not mention anything about details of the order, the areas, my lord, which are intended to be removed, no opportunity. I'll come to that. No opportunity. We've already come to a conclusion, my lord.
Still, you can file that there is no violation and therefore.
I get that. I'll come to that, my lord. And then about the complaint, my lord, all thing has been, a conclusion has been reached that I have gone on with an illegal constructions, and such a conclusion has been reached behind my back, my lords. Right, my lords? Now, can I take my lords to certain paras, my lords, of the writ petition? Now, this is, can I take my lords at page 10, para 5.7?
Given to principal secretaries of all states,
Why? Because there was a permission, my lords. Right?
accepting the entire
The petition is enclosing a certificate of 21/7/16 issued by respondent number 4, which goes to demonstrate that as per the permission granted by respondents, repair, renovation and reconstruction activity was carried out on the plinth area of 21,751 square feet. Out of the total plinth area is 41,751 square feet as per the permission is of 5/5/2012. And the remaining plinth area, even as of now, my lords, 20,000 square feet reconstructions had to be done.
Where is your building?
Motorcycle and
My lords, the permission P12, my lords, it's a 21/7/16.
Page number.
Practice
Permission
change.
order. This is
For last 6 years.
P11.
Let's come to the
Page
next.
P11.
Page 23, this is the third annexion.
Annexure is P11.
Let's come to the next. I'll read the second paragraph. There's a draft issued first. And the
This
second
comes at page
paragraph, and
76, my
whereas
lords.
copies of the said gazette
76,
notifications
yes.
were made available to the public on 29th May 2020.
आपके द्वारा
And whereas objections
दिए गए
and suggestions
आवेदन
received
दिनांक सो
from
इन सो के
public in
तारतम्य
respect of the said
में
draft
एवं इस
rules
कार्यालय द्वारा
have been
पूर्व में जारी
considered by the
प्रमाण
Supreme
पत्र
Court.
दिनांक सो इन सो
Now in
अनुमति
exercise of
पत्र
powers.
दिनांक सो इन सो अनाप्ति प्रमाण
Objections
पत्र सो इन
invited,
सो
suggestions
अनुमति
invited,
दिनांक सो इन सो
considered and what was
अनुविभागीय अधिकारी पिपरिया के
government
प्रमाण पत्र क्रमांक सो इन सो प्रमाण पत्र सो इन सो अनुविभागीय अधिकारी मुख्य कार्यपालन अधिकारी साड़ा किस्तल निरीक्षण पंचनामा दिनांक सो इन सो तहसीलदार पचमढ़ी के निरीक्षण पंचनामा दिनांक 18/4/2012 पूर्व म्युनिसिपल कमेटी पचमढ़ी के रिकॉर्ड एवं आवंटित भवन क्रमांकों साड़ा पचमढ़ी में उपलब्ध समस्त अभिलेखों पूर्व में पंजित क्रय विक्रय दस्तावेजों एवं स्थल निरीक्षण आदि के आधार पर प्रमाणित किया गया है कि गोल्फ क्यूब प्लॉट नंबर सो इन सो शीट नंबर सो इन सो सिविल एरिया साड़ा पचमढ़ी पर कुल निर्मित प्लिंथ एरिया 41751 वर्ग फीट है जिसमें कि निम्न प्लिंथ एरिया 21751 वर्ग फीट पर इस कार्यालय द्वारा पूर्व में जारी अनुमतियों के आधार पर रिपेयर रिनोवेशन एवं पुनर्निर्माण कार्य पूर्ण हो चुका है। दिस इज द प्रमाणीकरण मलोड्स।
In the explanation of serial number 3, a
This
transport
is,
vehicle shall
we
be
say
owned.
that this was
So,
there
my lord,
and
may rather
20,000 was
have
also
a
left
full
over.
form,
Now,
which is at
further,
page
my lord, we have
685
referred to because
of
it is nothing
Mr.
contra
Zaved.
to because they refer to the court. Is a apex code the Godhavarman. We have reproduced that my lord
एक मिनट पहले इसको तो पूरा
5.8.
पढ़ लें मैडम
किसको?
इसको ये ऑर्डर को
Further,
And how
respondent
it
number
reads
4.
today.
इसी प्रमाणीकरण my lords?
Did it read the same way when
प्रमाणीकरण
the table
उपरोक्त
was decided?
अनुसार
Or the
गोल्फ
reference order
प्लॉट
was
नंबर
made?
सो इन सो साड़ा सिविल एरिया महादेव रोड सो इन सो कुल क्षेत्र सो इन सो वर्ग फीट है जिस पर अनेक भवन वर्ष सो इन सो के पूर्व से ही निर्मित हैं। सन 1950 जिनका कुल प्लिंथ एरिया 41751 वर्ग फुट है जो कि कुल भूमि क्षेत्र का लगभग 25% है।
बिल्डिंग परमिशन आई आस्क्ड यू वेयर इज द बिल्डिंग
इसमें से सो इन सो वर्ग फुट पर इस कार्यालय द्वारा
आई
पूर्व में
आस्क्ड यू
अनुमति
वेयर इज द बिल्डिंग परमिशन
Next page is
शो मी द
तो ये
बिल्डिंग
तो
परमिशन
ये हो चुका है।
नहीं हो चुका होगा वेयर इज द बिल्डिंग परमिशन
motor vehicle, light motor vehicle.
First, you are required to
So
show
now
from the
the
building
concept of
permission
T and
that
NT
what was
goes away.
permissible. Then we will come to.
Light motor vehicle.
First, you are required to show
Now
from the
the
building
concept
permission
of T and
what
NT
was
goes away.
permissible. Then we will come to.
इसमें my lords
We have not- it's because states issue them, it might not have percolated by then.
These are actually in the nature of rules
We
itself.
have not- it's because states issue them, it might not have percolated by then. And look at the
ये आप
transport vehicle, how
P16
is it
देखिए my
used
lords,
now?
P17,
And how it
16
was used
P16
Mukundevangan.
this would come at page
Medium
would be
or goods,
100.
heavy goods or passenger vehicle as
7, 10,
transport
16 my
vehicle.
lords.
The concept of transport vehicle
पुनर्निर्माण बाबत
is no more
आपका आवेदन सो इन सो
LMV.
विषय
It is now
my lord,
confined to
नहीं, this is not the building permission.
विषय अंतर्गत पुनर्निर्माण हेतु सीट क्रमांक पर प्लॉट क्रमांक स्थित पुराने गैरेज सो इन सो कुल सो इन सो वर्ग फुट एरिया पर पुराने स्ट्रक्चर पर पुनर्निर्माण की स्वीकृति माननीय न्यायालय के निर्देशानुसार प्रदान की जाती है। इट वाज अ रिपेयर, इट वाज नॉट अ फ्रेश रिपेयर, अ रेनोवेशन, इट वाज नॉट, देयरफॉर दिस हैज बीन गिवन।
कब दिया गया?
ये 7/10/16 का सैंक्शन है।
ये तो बात की बात है।
According to
this has been
ये
omitted.
बात की बात है।
Earlier there is
7/10/16. Therefore, I say, my lord, in the letter which is under challenge, they do not say anything.
अच्छा ये 12/5/17 का पत्र कहाँ पर है?
12/5/17
जिसका हवाला दिया गया है 18/1/2018 को।
non-transport and vehicle include motorcycle with or without side gear, moped, three-wheeler, transport vehicle includes public service, goods carriage, educational, or private. 3.
इसके
Light
next
motor vehicle
क्या है
includes,
उसमें क्या
there's
लिखा
an
है?
omission here, my lord. Which the word here, which I read the original,
टाइप कॉपी नेक्स्ट में
amended rules,
पढ़िए please.
omission of the word transport vehicle. So
उपरोक्त
this
दिस इज
word transport vehicle has
गोल्फ
been
युग
omitted.
सो पचमढ़ी की अनुमति के अतिरिक्त कर लिए गए
So now
कार्य
it
को
is very
हटाने
clear.
बाबत इस
Because
कार्यालय
of
दिनांक
this
सो
exact
उपरोक्त विषय
provision that
अंतर्गत संदर्भ पत्र
transport
के
vehicle is
तारतम्य में दी
confined
गई अनुमति अनुसार अवलोकन किए जाने पर पाया गया कि आपके द्वारा गैरेज बरामदा अवाच सहित कुल 100 वर्ग फुट प्लिंथ एरिया का पुनर्निर्माण के अतिरिक्त 100 वर्ग फुट में अतिरिक्त कार्य किया जाना पाया गया है।
There is a show cause notice.
प्लिंथ एरिया
And you were saying कि वो
अब इसका जवाब
आया ही नहीं,
मतलब इसका जवाब देख ले मतलब
बताइए जवाब। शो कॉज
इसे
नोटिस
पेश नहीं किया गया
एंड यू वर सेइंग कि वो
अब इसका जवाब
आया ही
दिस
नहीं,
इज ऑफ
इसका जवाब
देख ले मतलब इसका जवाब तो है, पेश नहीं हुआ है क्या दिस इज ऑफ नहीं ये दूसरा है नहीं 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 पेश नहीं हुआ है नहीं इसका डेट P19 का माननीय अनुविभागीय मुख्य कार्यपालन अधिकारी ये तो अनुविभागीय है दिस इज इसका डेट P19 का माननीय अनुविभागीय मुख्य कार्यपालन अधिकारी इसका जो है ये पेश तो ये है पेश नहीं किया है इसमें गोल्फ सो एंड सो आपका पत्र दिनांक 12/5 का है ना साहब नहीं 7/10/16 12/5 गोल्फ सो एंड सो आपका पत्र दिनांक 12/5 का है ना साहब नहीं 7/10/16 12/5 गोल्फ सो एंड सो आपका मुख्य कार्य इसका तो जवाब दिया है ना इसने इसमें नहीं है 12/5 का मुख्य कार्य इसका तो जवाब दिया है ना इसने इसमें नहीं है 12/5/17 12/5 का इसका तो जवाब दिया है ना इसमें नहीं है 12/5/17 ये दिस इज रिगार्डिंग एक एक्सप्लेनेशन जो इन्होंने दिया है माय लॉर्ड्स टू द अनुविभागीय को P19A में है
हाँ P19 पढ़िएगा जरा इसको।
ये दिस इज रिगार्डिंग
आपने एक्सिस कंस्ट्रक्शन के बारे में क्या कहा है इस जवाब में?
इसमें ये कहा है ये कि उक्त
You have made counter allegations that the complainant's address be given so that you can set him right. He is trying to
नहीं जो टोटल एरिया जो इनिशियली हमने पढ़ के सुना है टोटल एरिया में जो दिया गया है
उससे नहीं, इसमें कहाँ लिखा है आपने कि ये 560 स्क्वायर फीट का निर्माण अतिरिक्त नहीं है इस पूरे जवाब में? मैंने तो पढ़ लिया 103 से 105 पेज तक। आपने कहीं पर भी नहीं कहा कि ये जवाब जो है एक्स्ट्रा नहीं है और जो है ये कंस्ट्रक्शन जो है इसलिए हटाए जाने योग्य नहीं है और ये नियमानुसार है।
इसमें जो मतलब इसमें जो इन्होंने
पहले जवाब तो पढ़ने
21 है
पहले जवाब पढ़ने P19 का फिर बताएं कि आपने शो कॉज नोटिस के जवाब में कहाँ बताया है।
दिस इज इन रिस्पेक्ट टू माय लॉर्ड्स जो इन्होंने दिया है अनुविभागीय अधिकारी का है ये दैट इज
वो नोटिस भी अनुविभागीय अधिकारी का ही है।
18 का जो 11/10/17 के तारतम्य में दिया गया है ये
जी जी और ये मुख्य कार्यपालन अधिकारी के नोटिस
नहीं इसमें जो नोटिस है मतलब P18 है 102 में के तारतम्य में दिया गया है इसी के इफ आई कैन जस्ट रीड मतलब उच्च न्यायालय इसमें निर्माण करने बाबत इस सूचना पत्र के जरिए आपको सूचित किया जाता है कि यह सूचना प्राप्त हुई है कि आपके द्वारा पचमढ़ी स्थित गोल्फ क्लब सो निर्माण किया जा रहा है। पचमढ़ी अंतर्गत निर्माण कार्यों पर माननीय उच्च न्यायालय की रोक होने के कारण आपके द्वारा किया जा रहा है ऐसा निर्माण कार्य अवैधानिक है। अतः आपसे निर्देशित किया जाता है कि आप किए जा रहे निर्माण कार्य का तत्काल बंद करें तथा निर्माण के संबंध में प्राप्त की गई संबंधित विभागों को अनापनी निर्माण कार्य का प्रकलन भूमि अर्जित करने के दस्तावेज विक्रय पत्र सहित अपना जवाब 23/10 को समक्ष में उपस्थित होकर प्रस्तुत करें। दिस इज व्हाट इट इज टू दैट माय लॉर्ड इज P19 at page 103
But first of all, notice was issued by the Chief Executive Officer, SADA, Annexure P17, pointing out that you have made over construction of 560 square feet. Permission was to construct 1346. Where is reply to this notice? There is no reply to this notice. Permission was to construct 1346. Where is reply to this notice? There is no reply to this notice.
Anything else?
Malad, there's few submissions, Malad, I'll take some time. Malad, something interesting falls from this proposition. Malad.
Anything else?
It is pursuant to Mukul Devangan's judgment that
ये मुख्य P20 my lords
today my lord is to
P20
not 94
A type copy 14/12/2017 का P20 my lords
my lord interprets this which is pursuant to her interpretation already given by the court. Can my lord today say no interpretation is something else and not what
ये मुख्य कार्यपालन अधिकारी को जो लिखा है
कब लिखा है?
विशेष दिस इज डेटेड 14/12/17
नोटिस कब का है?
rules are not in the child.
मुख्य
मई
कार्यपालन
17 का।
अधिकारी को जो लिखा है
It can't be set aside.
विशेष दिस इज डेटेड 14/12/17 इसमें बाधिका है इसमें लिखा है डिटेल लिखा
In order
है
to
क्या
If
लिखा
my
है?
lord permits me,
arrive at a
हाँ
conclusion
प्लीज।
given by the petitioner.
आज दिनांक को
One would have
आपके
to
द्वारा व आपके
set them
विभाग के
aside, turn
अधिकारियों
back
द्वारा
wheel of
संपत्ति
time,
का
go
स्थल
back to
निरीक्षण
Mukundan
किया गया इस
time,
संदर्भ में हमारा
interpret
स्पष्टीकरण
94
निम्न प्रकार है।
and then
ये कि
conclude
उक्त
agreement.
संपत्ति पर निर्मित 40/48 का गैरेज बरामदा क्षेत्र से सटा हुआ 31/40 का मंदिर एवं शौचालय क्षेत्र इस प्रकार का 79/40 के क्षेत्र सहित 12/24 का स्टोर ब्लॉक मिलाकर कुल प्लिंथ एरिया क्षेत्र 3448 वर्ग फीट 15 मीटर की ऊंचाई का निर्मित था। भारी बारिश में इसमें से 2865 वर्ग फीट क्षेत्र पूर्णतः नष्ट हो गया था। इस संदर्भ में हमारे द्वारा अनेक बार आपके कार्यालय में आवेदन प्रस्तुत करके निवेदन किया गया। हमारे आवेदन के अनुक्रम में आपके कार्यालय द्वारा हमें 2865 वर्ग फीट पर पुनर्निर्माण की अनुमति प्रदान की गई। तदनुसार हमारे द्वारा अनुमति प्राप्त करके निर्माण कार्य किया गया है। मिट्टी के दीवारों एवं अत्यंत पुराना निर्माण होने से शेष बचा संलग्न क्षेत्र भी ढह गया। हमारे द्वारा आपके कार्यालय में दिनांक 19/5/17 द्वारा आवेदन प्रस्तुत करके निवेदन किया गया कि चूंकि हमारा पूर्व निर्मित क्षेत्र 3448 वर्ग फीट था, अतः हमें संशोधित 3425 वर्ग फीट क्षेत्र पर निर्माण की संशोधित अनुमति दी जावे, क्योंकि 23 वर्ग फीट क्षेत्र पेड़ के कारण
नोट कर
हमारे द्वारा
ये डेट नोट कर लीजिएगा 19/5/17। यू सॉट परमिशन आफ्टर नोटिस वाज इशूड ऑन 12/5/17। These dates are very important.
इसी बीच लगभग 6 माह के अंतराल में 4 बार मुख्य कार्यपालन अधिकारी के स्थानांतरण के कारण हमारा आवेदन लंबित हो गया। चूंकि हमारे होटल में पृथक से पुरुष एवं महिला शौचालय नहीं है, इससे हमें भारी परेशानी हो रही थी। इस कारण शौचालय क्षेत्र को मिलाकर हमारे द्वारा कुल 3383 वर्ग फीट पूर्व निर्मित प्लिंथ क्षेत्र पर निर्माण किया गया है, जबकि वास्तव में निर्मित क्षेत्र 3448 वर्ग फीट था। इस प्रकार हमारे द्वारा 65 वर्ग फीट कम क्षेत्र पर ही निर्माण कार्य किया गया, लेस देन व्हाट वाज एक्चुअली डन।
He is giving a reply on all the aspects which are not part of the show cause notice. Show cause notice very clearly makes a mention of the fact that he was given permission to construct 1346 square feet of plinth area, garage बरामदा है, और आपने 560 स्क्वायर फीट ज्यादा कंस्ट्रक्ट कर लिया है। वहाँ सेट ऑफ नहीं होता है कि आपने एक कमरे में कम बना लिया एक जगह पे दूसरी जगह में। इस नोटिस का जवाब कहाँ है? पेज 101A का जवाब कहाँ है स्पेसिफिक कि हमने ये 560 स्क्वायर फीट का कंस्ट्रक्शन नहीं किया है एक्स्ट्रा, एंड देयरफॉर योर नोटिस इज अनकॉल्ड फॉर। वेयर इज द रिप्लाई टू दिस स्पेसिफिक फाइंडिंग रिकॉर्डेड बाय द अथॉरिटी? एंड देयरफॉर योर नोटिस इज अनकॉल्ड फॉर। Where is the petitioner resorting to saying anything here and there will not help him?
During the course of the hearing,
ये 19
one of the principal submissions.
Please come to page 101A.
I get that P17.
Pursuant to the judgment
Whatever
of
it
this
is, yes.
court,
Yes.
that the judgment of this
It's a
court
notice dated 12/5/2017. It makes a very specific
560 वर्ग फुट में अतिरिक्त कार्य किया जाना पाया गया, ठीक है?
जी, इसका कहाँ उत्तर है आपका? इतना बता दीजिए।
a notification
560 वर्ग फुट में
16
अतिरिक्त कार्य किया जाना पाया गया, ठीक है?
2018 by issuing notifications dated 16 April 20 March 2018, 16 April
ये कहना है कि
2018
उसी में
and
इंक्लूडेड
31
ऐसा, आई मीन दैट इज हाउ दे हैव ट्राइड टू ब्रिंग इट आउट, मतलब कि उसी में ही इंक्लूडेड है। दैट इज व्हाट हैज बीन नोटिफाइड।
बेदी साहब को भी कंसल्ट कर लेते तो अच्छा जवाब बन जाता।
जी,
बेदी साहब को भी कंसल्ट कर लेते तो अच्छा जवाब बन जाता।
ये तो इनके अस्तित्व में आने से पहले ही है।
अच्छा, इनके अस्तित्व में आने के पहले का। बेदी साहब को भी कंसल्ट कर लेते तो अच्छा जवाब बन जाता।
ये तो इनके my lord may take, well, I will do one thing. It can be taken up tomorrow, please.
नहीं, इसको भी विल फिनिश इट।
will be necessary to
नहीं, इसका हो नहीं सकता कि ये जवाब न दिया हो साहब।
बता दीजिए आप, यू हैव ऑल टाइम।
इसमें ऐसा है,
रखिए।
respond number 4 so and so further the same is demolished। तो यही तो इन्होंने डिमोलिश किया। पैरा 5.15 में
क्या है पैरा 1.5.1?
In my writ petition, page 15 में,
हाँ प्लीज बताइए.
that respondent number 4, white letter of 12/5/17 communicated petitioner that he had carried out reconstruction beyond
अब ये भी गलत है.
560, लिखा है ना 560 square feet.
नहीं 2865 गलत है, आपकी प्रीडिंग ही गलत है.
Beyond हमने किया.
बियॉन्ड नहीं, इस पे लिखा है, लिखिए ना, फिर से पढ़िएगा. 1346 लिखा है, आप ही ने टाइप कॉपी दी है. Because other copy is not readable. As per your copy, it is 1346, not 2865.
Yes, my lord, I heard your lordship's issued notice.
It is,
Learned attorney.
there seems to be some typographical error there, but it is, out of that, my lord, 560 square feet, it was been demolished. It has already been demolished, my lords.
But where is it mentioned that you have demolished? You have removed?
They have themselves demolished.
कब किया demolish? भैया आप
ये लेटर है 12/5/17 का.
अरे आप डिमोलिश नहीं किया है, 12/5/17 फिर से पढ़िएगा. 12/5/17 से डिमोलिश नहीं किया है. 12/5/17 से आपको कहा गया है कि आप उसको हटा लें.
Then sit down together and give us one, because then we don't have to go
अतः
back
आपको
and
इस पत्र
forth.
द्वारा आदेशित किया जाता है कि अतिरिक्त निर्माण एरिया किया गया, निर्माण तत्काल
Very right, हटा दे, तत्काल इसको हटा दे, right.
डिमोलिश नहीं किया गया.
नहीं, यदि ये as a matter of fact, with due respect, if this was there, the notice, my lord, which is the ultimate notice, which comes under challenge before this honorable court, P21, इसको हम थोड़ा सा देख लें, my lord. यदि नहीं हटाया गया होता तो, suppose, ऐसे it's been demolished, my lord. Now, what do they say? उपयुक्त विषय अंतर्गत जन सुनवाई अंतर्गत जांच कार्यवाही जाकर पाया गया कि आपके द्वारा सीओ द्वारा दी गई पुनर्निर्माण स्वीकृति के अतिरिक्त तथा विपरीत कार्य कर लिया गया है, जो कि माननीय न्यायालय द्वारा दिए गए दिशा निर्देशों का उल्लंघन है. एक तो ये पूरा इन्होंने कुछ बताया ही नहीं है. Nothing has been said, my lord. Is it 560? No, I come to that. दिए गए का उल्लंघन है. साथ ही सारा सीओ द्वारा दिए गए पत्र क्रमांक 12/5/17 द्वारा दिए गए आदेश को भी आपके द्वारा उल्लंघन किया गया. ये 12/5 ही का ही तो हमने कहा है कि सब इसमें इन्होंने
12/5 का कहाँ है आपने?
आपके द्वारा उल्लंघन डिमोलिश किया है. इसी को तो हमने कहा.
कहाँ लिखा है आपने कि आपने डिमोलिश कर दिया? 12/5 का पढ़िएगा थोड़ा सा,
Will be
बताइएगा
here for
कहाँ
the
लिखा है आपने?
NCT.
इसमें हमने ये लिखा है कि सर इसको आप मॉडिफाई कर दें.
तो फिर पिटीशन में क्यों आ
Others
गए
may not
modify
be
कराने
aware,
के
my
लिए?
lord.
नहीं हम आए ना, क्योंकि ऑलरेडी क्योंकि हमें सैंक्शन मिला है.
कहाँ है वो
I have
sanction?
no
वही तो
वो तो हमने
आपने
पढ़ के सुनाया आपको.
नहीं सेक्शन नहीं पढ़ा है आपने. जो P16 पढ़ा वो सर्टिफिकेट था कि कितना काम कंप्लीट हो
What
गया.
I read out.
First question to you was that where is the building permission? Building permission was obtained in 4 parts on different dates starting from the year 2003 to 2012.
Right.
I precisely asked you to show me from the building permission that what was granted, what has been constructed, and
Right.
I precisely asked you to show me from the building permission that what was granted, what has been constructed, and
Right.
I precisely asked you to show me from the building permission that what was granted.
इसमें my lord, if my lord has a perusal of P12,
P12, yes.
21/7/16 का.
Page number
At page it comes
79.
79.
जी.
Has a perusal of P12. This is Chief Executive Officer का है.
हाँ, page number.
आवेदक गोल्फ व्यू सोइंसो ने अपने आवेदन दिनांक सोइंसो 14/7/16 द्वारा व्यवसायिक गतिविधियों हेतु अनापति प्रमाण पत्र चाहे पूर्व में भी आवेदक को इस कार्यालय द्वारा अनापति प्रमाण पत्र क्रमांक दिनांक 10/7/2003 द्वारा जारी किया गया है.
Excellent.
चूंकि आवेदक गोल्फ
That is for conducting commercial activities. उसके लिए लाइसेंस दिया गया है. That is different. We are dealing with building permission. We are not dealing with license.
वो मैंने पढ़ के जो सुनाया था my lord आपको स्टार्टिंग में,
लाइसेंस दिया गया है. That is
कि
different.
that was the sanction that was given by them.
नहीं, it is not the sanction. It is only
For
a note that
reconstruction.
what work was completed.
That was the sanction that
There
was
is a
given by
specific
them.
notice on page 101 dated 12/5/2017, and there is no reply to that specific plea. Therefore, the impugned order cannot be faulted with. लिखिएगा. हाँ बताइए आप क्या कहना चाहते हैं. And there is no reply.
Kindly see my reply. R2 is the application preferred by the petitioner.
R2.
मतलब P11 का मैं I will reiterate P11 my lord.
P11 बताइए क्या लिखा है P11.
P11 के ऊपर ही
तो आप बता चुके P11 देख
that is what I'm trying to say. मतलब P11 में तो पूरा डिटेल दिया है. ये 21/7/16 का है. The area which has been given the permission, what we are trying to bring it out, my lord. The permission that was given for the total area has been indicated, my lords. And in fact, 20,000 square feet is left over, which we could have done it as per this order. Indicated, my lords. And in fact, 20,000 square. And that is what we have stated in para 5.7 onwards, my lord, in our petition.
ठीक है. Anything else?
This is number one, my lord. Number two, what we're trying to bring it out, that they say is contrary to the court's decision, my lords. For that, we have reproduced Godha Varman, my lord, and gone on to say that in fact, no, it cannot be construed to be as contrary. High Court ka to order was a PIL, my lords, that nothing like a cement or something, but there can be repair and a renovation can be there. Once a renovation permission has been given, which is on record, my lords, nothing like a cement or something, but there can be repair and a renovation can be there. We have said so very categorically, my lords, which is on record, my lords. If para 5.9, we have said so very that whatever has been done, the permission that was given, which was number 4 to grant permission with regard to 2865 square feet for covering all these, my lords. The permission that was given, which is P14, and we've gone on to say, my lord, that it's not a fresh construction that we are doing it, which is contra. Everything is within the plinth area, the height area, as per the decisions of the Supreme Court, and which is on record, my lords, along with the measurements which we have submitted. The decision of the Supreme Court comes in, my lord, at page, along with the measurements which we have submitted. This is at page 84, my lord, onwards. So we have very categorically stated.
Please read the relevant provision of Honorable Supreme Court.
P13 is the document. 12/8 is the order.
क्या order है?
And we come to page 84.
84, yes.
The relevant part would be the central. Can I read, please, at page 84?
Yes, yes.
The Central Empowerment Committee has submitted a report and made its recommendations in respect of the various issues pertaining to the areas falling within the Pachmari Wildlife Sanctuary. Insofar as recommendations in respect of the state of MP is concerned, the CEC has agreed to the area 395.939 so hectares of the Nuzul land falling in the Pachmari Plateau. Now, what we come, my lord, I come to 1, 2, 3, 4, 5, 6, 7 lines. I skip and I come, my lord. The condition that in the leased out Nuzul area, am I there, my lord?
Just a minute.
Just skipping the five lines, my lord, and coming to the condition that in the leased out Nuzul area, am I there, my lord? What they go on to say, this is the restriction.
The condition.
Yes, no new construction, either horizontal.
Nuzul area, new construction, either horizontal or vertical.
Vertical will be, and only renovation, reconstruction on the existing plinth area, subject to the flow area and height restrictions as per the applicable bylaws will be permissible. And this is what we have been repeatedly putting through our representation. The initial sanction that was given, and all within the ambit and umbrella of the directions of the Supreme Court, my lords. Now, what is more important, my lord, is all within the ambit and the para 5.11, which is P16, is a document. Respondent number 4, by his order of 7/10/16, they accorded sanction to reconstruct an area of the old garage, porch and temple, which was to the extent of 2865 square feet, my lords. An area of the old garage, porch and temple, which was to the extent of, and we've gone on to say in para 5.13, that in terms of the said permission, petitioner reconstructed an area including a common toilet, that the existing total plinth area prior to reconstruction was 344, including a common toilet, and 15-meter height, and petitioner reconstructed a total plinth area of 3383. With 14.5-meter height, and therefore there was no increase in the plinth area, my lords, nor the height of the structure was increased, and therefore we say that it was in accordance with. Somebody gives a complaint.
height में नहीं होता है.
The height of plinth, जो direction Supreme Court का है.
बात तो सुनिए आप. जो एरिया होता है वो स्क्वायर फीट में गिना जाता है. स्क्वायर फुट 2 डायमेंशन में होता है. 3 कोऑर्डिनेट्स होते हैं मैथ्स में, x, y एंड z. 3 डायमेंशन में जाएंगे तब हाइट इंक्लूड होगी. स्क्वायर फीट वो क्यूबिक मीटर में कैलकुलेशन होता है उसका. स्क्वायर मीटर में 2 डायमेंशंस का होता है. तो आपकी हाइट बढ़ाने से एरिया नहीं बढ़ जाएगा.
ये कहना चाह रहे हैं कि सर, as per the hidayat of the Supreme Court, because Supreme Court spelled it out that way, that is how they have tried to explain to their representative. Now, what is more important, which comes under challenge, my lord, is there is certain thing which is an impugned order. Now, the impugned order does not detail anything at all.
Yes.
Well, let me kindly see that. It doesn't give any details at all. What has been infringed upon. Now, this is the thing which is before my lords, the impugned order, which is P21, my lords. Now, a complaint comes to be filed against me. Am I not entitled to a hearing? This is what our submission is. On a basis of a complaint, an inquiry is conducted behind my back, and you reach to a conclusion saying that a particular portion or if this much area is an area which is for which it needs a demolition. So the core issue before this honorable court is, my lord would not be going into the other components with due respect. My lord would be looking into what P21 has to say at page 112. And a principal submission is, whatever is done at the Jan Sunwai cannot be taken to be as a Bible or a gospel truth. A person against whom or the authority is going to go against me, at least I must have an opportunity of hearing. And that was not done. And therefore, since there was a blatant violation, my lords, and since a sanction was accorded to us, and the extent to which the sanction was given, we had not brought about a reconstruction, my lord. Therefore, the second prayer follows for a modification, my lord. This is what I have to say.
My lord, kindly see Annexure R2, which is application filed by the petitioner to for grant of reconstruction.
R2 page number?
Page number 32.
32?
Reply. मेरी आपके कार्यालय में उक्त विषय में उक्त दिनांक को अनेकों बार आवेदन पत्र प्रस्तुत कर किए हैं, किंतु हमें अभी तक अनुमति प्राप्त नहीं हुई। पचमढ़ी की भारी बारिश के कारण संपत्ति के ठीक सामने स्थित गहरी क्षेत्र 40/48 एवं इसमें संलग्न बारंडा, मंदिर एवं पोर्च क्षेत्र कुल 2865 वर्ग फीट क्षेत्र पूर्णतः नष्ट हो गया है, जिसका आप स्वयं निरीक्षण कर सकते हैं। 31/40 का टॉयलेट प्लस 12/24 का टॉयलेट भी क्षतिग्रस्त हो गया है। संपत्ति के ठीक सामने होने से खंडहर भी वास्तु की दृष्टि से अत्यंत खराब है। अतः आपसे निवेदन है कि अभी फिलहाल 2865 वर्ग फीट पर पुनः निर्माण की अनुमति शीघ्र देने का कष्ट करें, भले ही शेष क्षेत्र पर बाद में अनुमति दे देवें। कुल प्लिंथ क्षेत्र 3425 वर्ग फीट पर पुनः निर्माण की अनुमति। दिस एप्लीकेशन माय लॉर्ड फॉर रिकंस्ट्रक्शन ऑफ द 2865 स्क्वायर फीट 2865। माय लॉर्ड पेज नंबर 100 पिटीशन, माय लॉर्ड काइंडली सी पेज नंबर 100 ऑफ द पिटीशन P16। माय लॉर्ड पेज नंबर 100। This is the permission on 2865 square feet.
Yes.
Married,
हाँ नहीं ठीक है, पढ़ लिया।
उसके बाद साहब ये जब P17 से हमने ओवर इन्होंने कंस्ट्रक्शन कर लिया, देन
समझ गए, वो आपने नोटिस दे दिया, उसके बाद में
उसके बाद मैं एक
किसका ऑर्डर कर दिया आपने?
R6 देख लें साहब एक बार।
R6
मार लिया,
समझ गए, वो आपने नोटिस
स्थल निरीक्षण प्रतिवेदन पेज नंबर 51 मान लो। R6 देख लें साहब एक बार। R6 मार लिया
जी।
सेकंड पैरा देख लें साहब। निरीक्षण के दौरान गोल्फ व्यू होटल के संचालक श्री प्रवीण महेश्वरी स्वयं टीम के साथ उपस्थित थे। तो साहब ये बैक बिहाइंड इंक्वायरी तो हुई नहीं। निरीक्षण के दौरान गोल्फ निर्माणाधीन स्थल देखकर तथा नस्ती की जांच कर पाया गया कि तत्कालीन सीओ श्री संजय मेहता द्वारा दिनांक 7/10/16 को पत्र क्रमांक 100 द्वारा सीट क्रमांक 14 प्लाट क्रमांक 6 पर स्थित पुराने गैरेज, बारंडा, मंदिर एवं पोर्च सहित कुल 2865 वर्ग फीट में ध्वस्त हुए पुराने स्ट्रक्चर पर पुनर्निर्माण की स्वीकृति माननीय न्यायालय के निर्देशानुसार प्रदान की गई थी तथा स्पष्ट किया गया था कि 2865 वर्ग फीट के अलावा किसी भी क्षेत्र में कोई भी अतिरिक्त कार्य न किया जावे, परंतु उक्त स्वीकृति बिना ड्राइंग एवं बिना नक्शे के प्रदाय की गई थी। उक्त अनुमति के लिए प्राप्त आवेदन के साथ होटल संचालक ने किसी प्रकार की ड्राइंग एवं नक्शा साडा कार्यालय में प्रस्तुत नहीं किया था और न ही स्वीकृत हेतु कोई शुल्क जमा करवाया था। साथ ही कोई स्वीकृत नगर तथा ग्राम निवेश कार्यालय द्वारा भी प्रदान नहीं की गई थी। अतः स्पष्ट है कि यह अनुमति पूर्णतः अवैधानिक प्रतीत होती है। मौके पर निरीक्षण के दौरान यह पाया गया कि उक्त स्थल पर भूतल पर कुल 3395 वर्ग फीट पर प्रथम तल पर 3395 वर्ग फीट तथा द्वितीय तल पर 2595 वर्ग फीट एवं निर्माण कार्य हो चुका है, जिसमें तीनों मंजिलों पर आरसीसी की छत डाली जा चुकी है, परंतु ईंटों की जुड़ाई अभी भी कुछ स्थानों पर होना बाकी है। भूतल पर 2865 वर्ग फीट के अतिरिक्त जो निर्माण कार्य किया गया है उसे संचालक द्वारा कॉमन टॉयलेट हेतु निर्माण कार्य करना बताया है। पूर्व सीओ द्वारा दी गई अनुमति में मंदिर, पोर्च, गैरेज एवं बारांडा क्षेत्र का उल्लेख है, जो कि भूतल पर ही स्थित होते हैं। निर्माणाधीन स्थल पर कोई भी
ऐसा कोई स्थान निर्मित नहीं पाया गया जिससे स्पष्ट है कि दी गई स्वीकृति के अनुसार निर्माण कार्य नहीं किया गया है। नस्ती पर पूर्व में भी अवलोकन किया गया, परंतु नवीन निर्माण से तत्सम्मित कोई नक्शा एवं ड्राइंग इत्यादि प्राप्त न होने से स्पष्ट है कि किया गया निर्माण पूरी तरह नियम विरुद्ध एवं अवैधानिक है। दिनांक 12/5/17 को तत्कालीन सीओ एवं अनुविभागीय अधिकारी राजस्व वरीय द्वारा पत्र क्रमांक 269 द्वारा अतिरिक्त 28/20 560 वर्ग फीट पर बिना अनुमति के कर लिए गए निर्माण को हटाकर प्रमाण प्रस्तुत करने संबंधी लेख किया गया था, परंतु संचालक द्वारा आदेश का पालन नहीं किया गया, जिससे पूर्वानुमति शून्य हो जाती है। साथ ही दिनांक 30/6/2017 को साडा कार्यालय से श्री पीके स्थापक उपयंत्री श्री दीपक आचार्य सहायक ग्रेड 3 तथा श्री अमजद खान कंप्यूटर ऑपरेटर द्वारा निर्माणाधीन स्थल की रिपोर्ट प्रस्तुत की गई थी, जो कि नस्ती के साथ संलग्न है। उपरोक्त अनुसार निर्माणाधीन स्थल पर जो भी कार्य किया जा रहा है उसकी वास्तविक ड्राइंग एवं अपना पक्ष प्रतिवेदन संचालक द्वारा आज निरीक्षण के दौरान प्रस्तुत किया गया है। साथ ही मौके पर तीनों फ्लोर पर हुए निर्माण कार्य के छायाचित्र लिए गए, वह भी प्रतिवेदन के साथ संलग्न प्रतिवेदन अवलोकनार्थ प्रस्तुत। मौके पर तीनों फ्लोर पर हुए निर्माण कार्य के छायाचित्र thereafter into order है प्रतिवेदन के साथ संलग्न प्रतिवेदन अवलोकनार्थ प्रस्तुत।
श्रीमती शोभा मैडम।
Can I say in reply, we filed a rejoinder, my lords.
जी
इन्होंने R2 के बारे में जो बोला है, my lords, ये P5 पैरा 5 में, my lord, of our rejoinder. इन्होंने R2 के बारे में जो बोला है, my lords, ये P5 पैरा 5 में, my lord, of our rejoinder. Para 5 of the rejoinder, my lord, we categorically stated, my lords, several letters that were submitted by them, my lords, by the petitioner herein, my lord. Para 5 of the rejoinder, my lord, we categorically stated, my lords, several letters that were submitted by them, my lords, by the petitioner. And further, my lord, if my lord has in sub-para of para 6, my lords.
Para 5 तो पढ़ने पहले।
Yes. That with regard to the facts in para 5 of the return petition humbly submits that in annexure R2 itself, the total plinth area was mentioned as 3425 square feet. Prior to submission of the letter dated 23/7/16 R2, petitioner submitted letters seeking permission for reconstruction from the said respondents by letter dated so-and-so, so-and-so, so-and-so. And the same has been referred in annexure R2 as also in the permission order of 7/10/16 P16. But due to the lackadaisical approach of the respondents, petitioner sought immediate permission for construction of an area at measuring 2865 square feet and pray that the permission for remaining area be granted at a later stage. But furthermore, para 6, sub-para, besides the CEO of the SADA in his certificate of 21/7/16, certified the entire layout plan of the Golf View Resort, which is enclosed as P1, P11, along with the writ petition. Now, if I can just
to you, P16 is the permission.
G. Then, my lords, we come to page 6. The last para of it, my lords.
16 is the permission.
Petitioner submits that the reconstruction activity undertaken by petitioner is in terms of the maps which are available with the officials of the respondents. Assertion of the respondent that petitioner has constructed the rooms is only incorrect, as petitioner has constructed reception hall and a conference hall for then existing plinth area and then existing heights of the structure. My lords,
Anything else?
my lords, may kindly have a perusal of para 8 at page 8.
जी
My lords, may kindly have a perusal. About others, my lord, it talks about others, how the permission has been given.
We are not
And
concerned.
I understand. Therefore, I'm skipping that. I'm coming to page 8,
I'll have to say
sub-para.
that you are not pressing this.
No, no, it may not be said that.
Yeah, I'll be saying that. Otherwise, you argue on it, I'll decide on it. I'll have to say that this is not a petition. How permission is given to others is not the subject matter of this petition. You argue on it, I'll decide on it. So,
I mean, to show the arbitrariness, my
no,
lords.
that is not the scope. That is not the scope and ambit of this petition. When you are challenging a specific order, then how the authorities have acted in relation to others is not the ambit and scope of this
But what,
petition.
because when we see, my lord, if my lord has a perusal that one of the grounds is an arbitrariness, my lord, when everything goes behind me and I'm not given an opportunity, my lords, it tantamounts to an arbitrariness. And just to highlight to this honorable court that there have been instances where the authorities have in a similar situations dealt with, my lords. That is how this paragraph comes in, my lords. Now, in view of the, now further in subparagraph of it, my lord, page 8, in view of the aforesaid action of respondents against the petitioner is discriminatory, as only constructed two-story building with a slope roofing attic on then existing plinth area and maintaining the earlier heights of the building, a fact duly certified by the chartered and the structural engineer through his certificate, which is a document appended along as P28. Right, my lords? It's gone on to say, my lord, in para 10, that the copy of the complaint is not given and not even annexed.
You are not supposed to, you are only,
Along with the return.
You are only supposed to give reply. to what
Because
he
the
has-
basis is the complaint, even along with the return, they have not filed the complaint.
ठीक.
Along with the return.
You are only supposed to give reply. to what
Because
he
the
has-
basis is the complaint, even along with the return, they have
और
not
क्या
filed the
बताना है
complaint.
आपको?
हाँ, just take it.
You are only supposed to give reply. to what he has-
ये है ना P29 और P29 जो इसके साथ एनेक्स किया टाइप कॉपी
P29 क्या है बताइए?
ये है ना P29 और P29 इसमें है टू द चीफ एग्जीक्यूटिव ऑफिसर माय लॉर्ड्स
किस तारीख का
इनका
है
जो
ये?
पत्र है 12/5/17 के तारतम्य में
हाँ,
इसमें
ये
है
कब है ये?
जो हमें 14/5 को मिला, ये 19/5/17
किस तारीख का? कहाँ डेट है? कहाँ है?
नीचे सबसे आखिरी में पेज 40 41
Why this was not enclosed?
रिजॉइंडर के साथ में
Why this was not enclosed with the petition? कहाँ डेट है? कहाँ है?
नीचे सबसे आखिरी में पेज 40 41
Why
that
this
was
was
maybe
not when- no, maybe नहीं.
but still it is on record my
No,
lords.
no, 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 no. You are
इसके
required
साथ में
to
पूरा showing the सब कुछ दिखा है
P29 का बताइएगा ये रिप्लाई आपने पहले क्यों नहीं रिकॉर्ड पर
still it
लाए?
is on record my lords.
You are
इसके
required
साथ में पूरा showing सब इसमें फोटोग्राफ सब तो
अरे
हमने
भाई
दिखा
हमें नहीं
दिया
मालूम है हम इतने इंटेलिजेंट
but
नहीं हैं।
it's my lord it's on record
इतना
my
सा
lords.
समझदार no. You are required to show. First,
But I am with due respect, I am not in a review that I have to explain all these things. It's a rejoinder, something which came out maybe not directly, which may have come indirectly. I can always take out in my rejoinder. my lord. Where is
this petition, let us read
embargo
about it.
came out maybe
पढ़िए पैरा 9 में।
not directly, which may have come indirectly.
क्या लिखा है
I
इसके
can always
बारे
take
में?
out in my rejoinder. Of my rejoinder.
Yes. ये डॉक्यूमेंट पहले रिकॉर्ड पर क्यों नहीं आया? क्या लिखा है इसके बारे में?
Of my rejoinder. But it gives, as my lord was anxious about it, the averments made by respondents that petitioner has not replied to the show cause notice of Barapan, therefore the show cause notice dated 11/10/17 was issued is factually incorrect and the same has been pleaded ignoring petitioner's pleading in para 5.15, where it was specifically stated that replying to the show cause notice dated Barapan, petitioner submitted his reply come application for modification of the permission order of 7/10/16 and requested respondent number 4 to modify the permission order so as to include the reconstruction for toilet facility for men and women to the extent which I just read it, 3425 square feet, which petitioner has been claiming since beginning, and the same is still pending for its consideration. Despite the positive recommendations made in that regard, no final decision is taken on petitioner's said application on this part. As such, the impugned order is not tenable in law in view of the pendency of the said application. Copy of the reply comes so-and-so of so-and-so 19.5 is filed. And there, my lord, it gives everything in detail, my lords. Copy of the reply comes so-and-so of so-and-so. Because my lord had a principal query on this, my lords. And therefore, if I can just read that, my lord, P29, page 39. आपके ऊपर 14/5/17 को प्राप्त हुआ, जो 12/5 का था वो हमें 14 को मिला।
उसमें जो तथ्य की बात है उतना पढ़ के बताइए, पूरा मत पढ़िए।
हमारा स्पष्टीकरण हम लिखा उपरोक्त संपत्ति
जो आप
पक्ष
उसमें आपने जो स्पष्टीकरण दिया है वो स्पेसिफिकली पढ़ के बताइए कि 560 फुट के बारे में आपने क्या स्पष्टीकरण दिया है।
तो इसमें आप इसमें
उतना
इतना सा देख लें क्योंकि पूरा
आई विल नॉट रीड कंप्लीटली, यू जस्ट पॉइंट आउट 560 स्क्वायर फीट के बारे में शो कॉज नोटिस था, उसके बारे में आपने किस लाइन में कहा उतना बता दीजिए। यू जस्ट पॉइंट आउट 560 स्क्वायर फीट के बारे में शो कॉज नोटिस था, उसके बारे में आपने किस लाइन में कहा उतना बता दीजिए।
पर इसका तो कुछ हुआ तो कंसिडरेशन ही नहीं हुआ।
चलिए यस लिखिएगा, दिस पिटीशन इज फाइल्ड श्रीमती शोभा मेनन, लंडेड सीनियर एडवोकेट असिस्टेड बाय श्री बेदी for the petitioner. Shri Manas Mani Verma, learned government advocate for state. This writ petition is filed for the petitioner seeking setting aside of order dated 8/1/2018, annexure P21, passed by setting aside of the order dated 8/1/2018 subdivisional officer within bracket revenue and executive magistrate Piparia whereby petitioner was directed to remove his illegal construction within a period of 7 days of receipt of the notice, failing which it is ordered that all the illegal construction shall be removed at the government cost by the government authorities at the cost of the petitioner, for which petitioner will be liable to reimburse the cost to the state. Next paragraph. Learned Counsel for the petitioner submits that petitioner is in possession of a old property at Pachmadi. Full stop. In terms of the decision of the Honorable Supreme Court, in case of in terms of the decision of the Honorable Supreme Court, T.N. Godavarman, Thiru Mulpad, THIRUMULPAD versus Union of India and others, wide order dated 12/8/2013, when the matter was taken up by the Honorable Supreme Court, then Honorable Supreme Court in IA 2202-2203 had directed that Henley had observed that the Central Empowered Committee had submitted a report and made its recommendations. ये inverted Central Empowered Committee से inverted commas में ले लेना. Recommendations in respect of the various issues pertaining to the areas falling within Pachmadi Wildlife Sanctuary. Full stop. Insofar as the recommendations in respect of the state of Madhya Pradesh is concerned, the CEC has agreed to the area 395.939 hectares of the Nazul land falling in the Pachmadi Plateau to be excluded from the Pachmadi Sanctuary. Full stop. Inverted commas close. The recommendation, inverted commas close, full stop. The recommendation further states that an area of 135 hectare of Nazul area, which falls in the category of deemed forest and is considered important from the wildlife management point of view, may continue to remain within the sanctuary, subject to the condition that in the leased out Nazul area, no new construction, either horizontal or vertical, will be permissible, and only renovation / reconstruction on the existing plinth area, subject to floor area and height restrictions as per the applicable bylaws, will be permissible. Full stop, inverted commas close. Next paragraph. Thus, reading from this judgment, it is submitted that petitioner had carried out construction in pursuance of the decision rendered by Honorable Supreme Court in case of Godavarman, and this aspect has been certified. Rendered by Honorable Supreme Court in case of Godavarman, and this aspect has been certified by the authorities, as is evident from a certificate dated 21/7/2011, 2016, Annexure P11, which according to the petitioner reads that which according to the petitioner has been issued by the Chief Executive Officer of a Special Area Development Authority Pachmadi, certifying that total constructed area of the property, namely Golf View, situated at plot number 8, sheet number 14, Sada, civil area, Mahadev Road, is 1,66,209 square feet. इसको words में लिखिएगा bracket में. The building was constructed prior to 1950. Plinth area of the building is plinth area is 41,751 square feet, which is about 25% of the area of total land. Full stop. As per the earlier permissions, repair, renovation and reconstruction has been undertaken on 21,751 square feet, full stop. Remaining area of 20,000 square feet is available for reconstruction besides a swimming pool on area measuring 40 into 80, full stop. Reading this document annexure P11 dated 21/7/2016, it is submitted that petitioner is still left with sufficient area of about 20,000 square feet for construction. Therefore, the plea mentioned, therefore the therefore the therefore the impugned order mentioning violation of building permission and excess construction being made is uncalled for. Next paragraph. Srimati Shobha Menon submits that impugned order does not detail anything. It is a cryptic order. No opportunity of hearing was given to the petitioner before passing impugned order dated 8/1/2018, annexure P21, full stop. It is also submitted that the said order is arbitrary and illegal and having been passed in violation of the principles of natural justice is liable to be set aside. Next para. Srimati Shobha Menon has also taken this court through the replies which were filed by the petitioner as are contained in annexure P14C dated 4/10/2016 and the one which is filed as P19 dated 16/10/2017. Besides the document enclosed along with the rejoinder as annexure P29 to demonstrate that the reply was promptly filed by the petitioner to the notice dated 12/5/2017 and without considering that reply and other replies filed by the petitioner from time to time, impugned order has been passed. Next para. Shri Manas Mani Verma, learned counsel for the respondent state, in his turn submits that petitioner's plea of not giving any opportunity of hearing is inappropriate. Full stop. In fact, a show cause notice was issued to the petitioner as is contained in annexure P17 dated 12/5/2017. Full stop. It is pointed out that building permission was given to reconstruct 2,865 square feet of area as is evident from the building permission contained in annexure
P16.
P16 dated 7/10/2016, but petitioner made an over construction of 560 square feet as is evident from notice annexure P17. Full stop. Thus, first plea of the petitioner that no show cause notice or opportunity of hearing was given to the petitioner is belied from its own reply dated contained in annexure P29. Full stop. Though Shri Manas Mani Verma disputes this document and submits that it is a document which has been prepared as an afterthought, otherwise petitioner would have enclosed this document along with the petition. Full stop. It is also pointed out that there is a typographical error in the typed copy of annexure P17 and instead of showing actual area of 2,865 square feet, it is inappropriately mentioned as 1,346 square feet. Full stop. Next paragraph. Shri Manas Mani Verma drawing attention to the annexure R2, page number, yes, sir. Annexure R2 dated 23/7/2016 points out that Even the petitioner had accepted that permission was granted only to reconstruct a area of 2865 in place of the dilapidated garage and surrounding area of veranda, temple and porch, etc. Full stop. This admission is available in the form of Annexure R2. Thereafter, in presence of the petitioner, a detailed Sthal Nirikshan Prativedan, that is spot inspection report, was prepared as is contained in Annexure R6 dated 14/12/2017, and in this report it has come on record that there was an excess construction of 560 square feet. Full stop. Next paragraph. Thus, Shri Manas Mani Verma submits that order Annexure P20, impugned order Annexure P21 is when read in continuation of order Annexure P17, which is a show cause notice, and Annexure R2, which is the communication made by the petitioner himself admitting that permission was granted only to reconstruct an area of 2865 square feet, and then the spot inspection report dated 14/12/2017, then it is apparent that there was an excess construction of 560 square feet.
Can I
But-
interject, please,
नहीं,
my lords?
Not now. क्या लिखा? Square feet, full stop. Shri Manas Mani Verma has taken this quote through various replies and communications made by the petitioner. Full stop. The first full stop. There is a communication contained in Annexure P18. P18 nahi, I'm sorry. P19, which is the so-called reply to the letter dated 11/10/2017. Full stop. In Annexure P19, there is no mention of earlier show cause notice dated 12/5/2017. Full stop. There is no mention of earlier reply as has been filed by the petitioner as Annexure P29. Full stop. There is no mention of the requirement of, there is no rebuttal to the allegation made in the show cause notice Annexure P17 that petitioner has made an excess construction of 560 square feet. Full stop. Even Annexure P29, though makes several allegations in regard to discrimination, etc., but there is not a single word to point out that the allegation of making extra construction of 560 square feet is unfounded, is not founded on appropriate material, or the spot inspection report is illegal or arbitrary. Next para. Thus, on the strength of the communication made by the authorities only as contained in Annexure P11, petitioner is trying to make out a case that since petitioner was left with 20,000 more square feet of area, petitioner has the flexibility and choice to carry out that construction as per his whims and desire. Full stop. Next para. This court asked Srimati Shobha Menon that to show from the building permission that what was permitted and what has been constructed, but no building permission has been brought on record by the learned counsel for the petitioner. Full stop. Attention is drawn to Annexure P11, which is a certificate and not the building permission. Full stop. Next para. Srimati Shobha Menon at this point, reading from the rejoinder, submits that in para 9 of the rejoinder, a specific plea has been para 5 of the rejoinder, a specific plea is taken that total plinth area in R2 itself is mentioned as 3425 square feet, and prior to submission of letter dated 23/7/2016, Annexure R2, petitioner submitted letters seeking permission for reconstruction from said respondents via letters dated 3/6/2016, 21/6/2016, 14/7/2016, and 23/7/2016, and the same has been referred in Annexure R2 as also in permission dated 7/10/16 Annexure P16, but due to lackadaisical approach of the respondents, petitioner sought immediate permission for construction over an area at measuring 2865 square feet and prayed that the permission for remaining area be granted at later stage. Full stop. Similarly, reading from para 6 to the rejoinder, it is pointed out that if the permission order dated 7/10/2016, Annexure P16 is minutely scrutinized, it is evident that in the said order, petitioner's previous applications dated 6/6/16, 21/6/16, and certificate along with layout plan dated 21/7/16 were specifically referred. As such, it is totally incorrect on the part of the respondents that petitioner has not submitted any map/drawing along with application for reconstruction of the disputed.
As my lord is going through the rejoinder, sub-para 7 may be also seen because
अभी आप देखिए तो अभी तो 6 लिखा है, इतना have patience.
sub-para जो 7 है,
अभी
जिनकी
आप
जो इनकी बातें हैं उसके संदर्भ में
लिखने तो दीजिए, बीच में इंटरप्ट मत करिए प्लीज. Full stop. Similarly, on internal page 6 of the rejoinder, reading from internal page 6 of the rejoinder, last paragraph, it is submitted that petitioner has clearly mentioned as under, within inverted commas, for the sake of repetition, petitioner submits that reconstruction activity undertaken by petitioner is in terms of the maps, which are available with the officials of the respondents, full stop. Assertion of respondents that petitioner has constructed the rooms is wholly incorrect, as petitioner has constructed reception hall and conference hall on the then existing plinth area and then existing heights of the structure. Next para. Learned counsel for the petitioner also reading from para 8 of the rejoinder.
मतलब 7 का इसीलिए मैं बोल रही हूँ क्योंकि आपका ये कहना है काउंसिल का read 21 along with 17 what is not in the order cannot be supplemented through an affidavit. This is Gill's decision way back in 78 Supreme
Okay,
Court.
लिखिएगा.
तो कहा नहीं है तो वो कहाँ से लिखा नहीं है तो
At
कहाँ
this
से देख
stage,
सकता है
at
कोर्ट?
this stage, learned counsel for the petitioner adds a new argument that when in order annexure P21,
Yes.
there is no mention of
P17.
annexure P17, which is the show cause notice, then it cannot be read into. Full stop.
Right, my lords.
This argument can be dealt with right now in as much as this submission made by the learned counsel for the learned senior counsel for the petitioner is erroneous on face of the record. There is a specific mention of the order annexure P17 in as much as it is mentioned as under, within inverted commas. हिंदी में लिखिएगा. उपरोक्त विषय अंतर्गत ये लिख लीजिएगा पेज 112 पे, जितना मैं ब्रैकेट लगा रहा हूँ उसमें स्पेसिफिकली इसको हाईलाइट कर दीजिएगा. साडा सीईओ द्वारा दिए गए पत्र क्रमांक 269 दिनांक 12/5/17 द्वारा दिए गए आदेश का आपके द्वारा उल्लंघन किया गया है. इसको कॉपी कर दीजिएगा. Thus, it is evident that learned senior advocate has failed to read the impugned order in the correct perspective, in as much as there is a direct and specific mention of the show cause notice dated 12/5/2017.
उसका जवाब
And
भी
as
आपने
has
दिया है
been-
ना साहब?
अब बीच में ना बोले प्लीज. And this has not been answered as has been mentioned above while bringing so-called reply on record along with the rejoinder in the form of annexure P29. Full stop. There is no whisper in regard to extra construction being inappropriately mentioned or that the extra construction has not been made. Even with the reply annexure P29, no map has been enclosed, sanctioned map has been enclosed to demonstrate that in fact that 560 square feet of construction was allowed while giving permission to make construction of 286535 कितना है
560
हाँ
560
अरे नहीं भाई 28 कुछ है
2865
2865 square feet of area wide annexure P16 full stop. Next para. Thus, full stop. In para 9 of the next para 9 of the rejoinder, petitioner has taken a plea of being discriminated in the matter of giving grant of building permission, etc. It is mentioned in para 9 of the rejoinder as referred by Srimati Shobha Menon that the para 8 that the act of the respondents against the petitioner is patently discriminatory as petitioner has only constructed two-storied building with slow proofing oblique attic on the then existing plinth area full stop. Next para. It is evident that all these pleadings which have been taken by the petitioner are not in conformity with the show cause notice dated 12/5/2017. There is no specific denial to the said over construction. There are allegations and counter allegations. Petitioner's desire was as reflected from annexure P19 that name of the complainant be disclosed to him so that he along with the phone number and address etc so that he can take action against the complainant. Full stop. That is not the scope of this petition. Full stop. Petitioner is required to carry out construction in accordance with the permission granted in that behalf. Full stop. That is the ratio of the decision of Honorable Supreme Court as has been reproduced above. Full stop. At the cost of reproduction, comma, Honorable Supreme Court has categorically said that the construction will be that no new construction either horizontal or vertical will be permissible and only renovation or vertical will renovation oblique reconstruction on the existing plinth area subject to floor area and height restrictions as per the applicable bylaws will be permissible. Applicable bylaws को highlight कर दीजिएगा. Therefore, petitioner in reply to the show cause notice was required to show that construction made by the petitioner is in accordance with the bylaws that are applicable to the area. Full stop. But petitioner, instead of answering to the show cause notice, denying the fact of over construction, has given twisted replies, giving different facts which were not the subject matter of the show cause notice, and same is the status of the documents filed along with the petition. None of the replies filed by the petitioner in response to the show cause notice contained in annexure P17 makes specific denial of making over construction of 560 square feet against the permission for 2865 square feet. Therefore, impugned order having been passed after giving opportunity of hearing to the petitioner, for which notice was issued as contained in annexure P17 and which now came to be accepted in the form of so-called reply contained in annexure P29 brought by the petitioner on record along with the rejoinder, and then subsequent reply contained in annexure P19, comma, impugned action of the respondents who are the guardians of the local bylaws and who have a duty to maintain the sanctity of a reserved area or the area left out by the Forest Department under certain terms and conditions of the orders of Supreme Court, comma, it cannot be said that the impugned order making mention of two facts, namely violation of the orders of the Supreme of the Court and violation and violation of the permission of the CEO, comma, cannot be faulted with. Both the conditions are prima facie made to be violated by the are appears to have been violated by the petitioner, as has been discussed above. Therefore, impugned order does not call for any indulgence. Petition fails and is dismissed. Parties to bear their own cost.
Greatly obliged, my lords.
Number 17. Kumar Singh, Kumar Mishra.
Because in this, I have filed an application for disposal of the petition minutes. The petition relates an integrated development of small and medium scale towns, minutes. Under the said scheme, certain amounts were disbursed to the municipalities of small towns by the central government, and upon completion of project.
Who are you? Who are you?
I
Ex-Vice President, Municipal Council Umaria. What is your locus? कितनी cost? ये सब cheap publicity की petitions है. कितनी cost? If Municipal Council has any grievance that under centrally sponsored schemes, some funds have not been disbursed, then the locus is of the mayor in council or of the chief municipal officer, as the case may be. What is your locus?
Actually, funds have to be returned back to
Please show me your locus first.
The petitioner.
Cost बताइए कितनी cost लगाएं ये भी बता दीजिएगा.
The
पेपर में कल छपेगा. आपको जो शौक है पेपर में नाम छपवाने का वो आएगा cost के संदर्भ में. सरकारी वकील साहब छपवा दीजिएगा कल इसको. इतनी cost लगा के इनकी petition खारिज की गई.
My lords, may kindly see para 5.2 for my.
आप पहले locus बताइए फिर सब देखेंगे.
Locus is explained in 5.2.
5.2
my lord.
2 बताइए.
The petitioner, my lords, is a social worker. He has been ex-president, my lords. Even
बताइए आपकी history बताइए काम करने की poor लोगों के लिए. What work you have performed for the poor?
I can bring that on record, my lords. I have been involved.
Please show me from the record that what work has been carried out by you for the poor and how the prayer made in this petition is for the poor people. Please correlate that.
That is not on record, my lords. However, I have been involved in the municipal council for many years.
By Shri Vasu Jain. Shri
Abhishek Singh for respondent number 4.
Shri Vijay Kumar Shukla, learned panel lawyer, for respondent number 1 and 2.
Respondent number 5. NK Mishra.
Shri NK Mishra for respondent number 5. Shri
Abhishek Singh for respondent number
Abhishek Singh for respondent number
4.
4. Full stop. This petition is filed seeking issuance of a writ of mandamus directing the respondent number 5, that is the Chief Municipal Officer, Municipal Council Umaria, to deposit the remaining fund with the IDSMT within stipulated time. What is this IDSMT?
This is, my lords, integrated development of small and medium.
कहाँ लिखा है बताइए ना.
Just a moment. This is 5.3, my lords.
5.3. IDSMT में लिखिएगा integrated development of small and medium towns. Full stop. Petitioner is a ex-vice president of Municipal Council Umaria. What locus he has to file this petition is not disclosed except what is mentioned in para 5.2, that petitioner is a social worker and always raising the voice for betterment of poor persons and also work for interest of state. He was vice president of Nagar Palika Parishad Umaria with effect from 12/2/2013 till his completion of tenure. Full stop. As far as post of vice president of Nagar Palika Parishad is concerned, it's an elected office. Full stop. There is no material available on record to show the antecedents of the petitioner as a social worker and the work carried out by him for the betterment of poor persons. Full stop. On the face of the record, petition appears to be a publicity-hungry petition. Full stop. There is no locus of the petitioner to claim the relief against the CMO of the municipality. Full stop. In absence of locus of the petitioner, his petition deserves to be and is hereby dismissed for full stop. Petitioner shall bear cost of the respondents, which is quantified at rupees 25,000 to be deposited in High Court Legal Services Committee within 30 days from today, failing which Secretary of the High Court Legal Services Committee shall be entitled to recover the cost by issuance of RRC against the petitioner.
My lords may be so inclined, I may be allowed to withdraw the petition, my lords.
Withdraw का cost तो लगेगी जी सर, आप बताइए.
मैं एक अनुरोध करना चाहता हूँ, आइटम नंबर 19
जी.
Would it be taken on Monday, Lord?
हाँ, लिख लीजिएगा.
Government advocates should be directed to have the record for your lordship's perusal, because I am pointing out many flaws that such notifications have not been. Maybe wrong.
20 नंबर में लिखिए. श्री 19 में सॉरी.
19.
श्री RN सिंह, learned senior advocate, assisted by श्री Saurabh Pathak, श्री Manas Mani Verma for the government. श्री RN Singh prays for listing of this case in the next week, with a direction to the state government to keep the record of the proceedings present. Full stop. Shri Manas Mani Verma undertakes to keep the record present list next week. हाँ बताइए.
This is item 23.
हाँ.
Concerns CCI's.
Lunch के बाद आएंगे हम. I'm not.
I'm sorry, Malaz.
I will be available after lunch.
I'm so sorry, Malaz. I was told that.
नहीं, I will be available after lunch.
Please, Malaz.
Your Lordship, I'm seeking audits. Supply the oblige, Your Lordship.
सर एक मिनट, ये कुछ कहना चाहते हैं, इनको सुन ले।
सर 15 नंबर वो जजमेंट
हैं?
वो जजमेंट को आइटम नंबर 15 पे
जी जी।
I'm so sorry to trouble your lordship.
नहीं, प्लीज बताइए, प्लीज बताइए।
23 listed before your lordship in the
मोशन हियरिंग, yes, Sintu Varghese.
correct.
Yes.
CCI pertaining to the district of Sagar.
Huh.
The order was passed by some by the CWC here for the movement of free children. Your lordship said stayed the order.
Yes.
I am now coming from Delhi. I present NCPCR.
Yes.
Yes. On 11th before your lordship. This very same matter.
Okay.
I am sorry, I don't know the procedure.
नहीं, please tell me, please tell me.
Today.
Yes.
There's only one request. Presence mark in the IA. A permission can be given to whenever the matter reaches next, I will be permitted to join through VC.
So you can always join in this court. You are always permitted to join through VC. That is not an issue. Shri, what's your good name?
Abhed Parekh.
Shri Abhed Parekh.
Along with Mr. Akshat Harjari.
कहाँ है? Where is Mr. Akshat Harjari? उसके लिए अभी आप सीनियर एडवोकेट डेजिग्नेट हो गए क्या? फिर बस अभी अपना अलग का अपना नाम लिखाइए, लिखिएगा। Shri Amit Mishra for the petitioner, Shri Abhed Parekh for the intervener. Shri Parekh submits that he has filed some application IA 10238 of 23, an application for intervention. Let reply to the said application be filed by the petitioner within 15 days. Shri इनका नाम डाल अभी अनुभव जैन फॉर रिस्पॉन्ड नंबर फॉर फर्स्ट डेट, ठीक है। लिस्ट इन द वीक कमेंसिंग 21 अगस्त 2023। चलिए।
Please, my lord, highly appreciate.
Application serial number 1.
ये वही मैटर जो चल रहा था, दिस इज समथिंग डिफरेंट मैटर। वो तो शायद 24 तारीख के लिए लगा है।
वो 24 वाले हफ्ते में।
24 वाले हफ्ते में। जी जी सर, जी सर।
दिया है ना पहले अभी
सर है, इसमें कॉपी है कॉपी है सर, मैं इनको दे देता हूँ, है।
It's a long synopsis according to me.
नहीं,
but relevant portions are
3, 4 and 6.
3, 4 and 6.
We'll go through together.
Introduce the subject.
हाँ, please, sir.
In writ petition filed an order in P9, 8th November 1999 was questioned. And at page 3 we will find on 3rd August 2000 petition was allowed relying on a particular case. Possession not taken, sealing proceeding under section 4 है submitted.
ये अर्बन सीलिंग का मैटर है।
अर्बन सीलिंग का
रिकॉर्ड है आपके पास में अर्बन सीलिंग का रिकॉर्ड? तो रिकॉर्ड के बगैर कैसे होगा?
तो लगेगा।
हाँ तो लगेगा।
तो लगेगा रिपीटेड ऑर्डर से ऑर्डर शीट में भी।
कहाँ का मैटर है? लोकल का मैटर। तो क्यों नहीं बुलाया आपने रिकॉर्ड? देखिएगा, श्री रवीश अग्रवाल, लर्नेड सीनियर एडवोकेट, असिस्टेड बाय श्री, आपका शुभ नाम बोलिए प्लीज। जसबीर गुलाटी, जसप्रीत गुलाटी। श्री मानसमणि वर्मा, लर्नेड गवर्नमेंट एडवोकेट फॉर स्टेट। नेक्स्ट पर लर्नेड गवर्नमेंट एडवोकेट raised for time to keep the record of the proceedings available. Full stop. Time was granted on 14/6/23. By way of last indulgence, 7 days time is granted to call for the record list along with the record. कब convenient है आपको? Next week में तो वही वाला मैटर आएगा 24 तारीख को।
उसके बाद वाले में करते हैं।
अच्छा, उसके बाद वाले में in the week commencing 31 जुलाई 2023। हाँ हाँ, तो आपका नाम डाल दिया उसमें भाई। अच्छा, तो इतनी सी बात है, IR टू कंटिन्यू कर दीजिएगा। आप ही ने लिखा था ना वो जिसमें मिस्टर पारिक अपीयर हुए थे, उसमें डाल दीजिएगा IR टू कंटिन्यू। यू फाइल रिप्लाई टू दैट इंटरवेंशन एप्लीकेशन। जी सर, आप कुछ कह रहे हैं?
ये आपसे मैंने दिया था।
अरे ठीक है सर, थैंक यू।
नंबर 3
Kindly this matter be remain in the list, Lordship.
अरे भैया, हमें कोई दिक्कत नहीं है इसको लिस्ट में रहने में। आप कब बहस करोगे? आई एम वेटिंग फॉर यू टू आर्ग्यू।
Lordship,
आप अपनी कन्वीनियंट डेट बताओ, उस डेट को लगाते हैं।
Lordship में
आई वॉन्ट यूर फ्यूचर ऑफ दिस बार। ठीक है, आप कब बहस करोगे? आप अपनी कन्वीनियंट डेट बताओ।
Lordship इसमें सीनियर बहस करेंगे Lordship, और मैं नेक्स्ट वीक चाह रहा हूँ Lordship।
नेक्स्ट वीक नहीं, अब तो फिर लिखिएगा। श्री धीरज तिवारी, लर्नेड काउंसिल फॉर द पिटिशनर, again prays for adjournment. Full stop. This case has been adjourned on his request in the past also. By way of indulgence, case is adjourned. List in the week commencing 16 अक्टूबर 2023।
वो लिस्ट से बाहर नहीं जाएगा ये?
हैं? लिस्ट में ही रहेगा ये? हाँ तो रहने दीजिए फिर। लिस्ट केसेस एडजॉर्न, बस विद क्लियर अंडर डेट मत डालिए। विद क्लियर अंडरटेकिंग दैट on the next in the next week case will be argued finally, failing which petition may be dismissed for want of prosecution.
2 बार तो खारिज हो गई थी वांट ऑफ प्रोसिक्यूशन।
अब मेरिट पे बता दीजिएगा, मेरे यहाँ लगेगा तो मैं मेरिट पे कर दूंगा।
कहीं नहीं जाएगा, यहीं रहेगा।
नहीं, जहाँ जाना है जाइए, उसका कोई
नहीं हटेगा नहीं सर।
किसी मुकदमे की कोई तलाश नहीं है।
नहीं साहब, पर हटेगा नहीं। दिस इज द लिस्ट
नोटिफिकेशन है, उसके आधार पर लिस्ट जब तक
चीफ जस्टिस की ऑर्डर पे तब तक लिस्ट हटेगी नहीं।
फिर आप किसका इंतजार कर रहे हो? इनके मुताबिक जाएगा भी नहीं यहाँ से बाहर। हाँ ठीक,
जब चाहते हो तारीख बताते हो।
आप तो तारीख बता दो, हम उस तारीख को रख देते हैं। हम आपसे यही तो रिक्वेस्ट कर रहे हैं। नेक्स्ट वेडनेसडे लिखिएगा भाई, ऑन रिक्वेस्ट ऑफ श्री धीरज तिवारी लिस्ट दिस केस। नेक्स्ट वेडनेसडे को नहीं हो पाएगा, उसके नेक्स्ट में रख देते हैं। दिस केस ऑन 2nd August 2023, where this case will be taken up as the first case during the final hearing. कंपनसेशन का मैटर है ये। यहाँ कैसे इसके लिए लॉ ऑफ टॉर्ट्स में दे विल हैव टू गो टू द सिविल कोर्ट टू।
सुप्रीम कोर्ट का एक फैसला है, उसमें दे सकते हैं। बाकी वो मजिस्ट्रेटियल इंक्वायरी हो चुकी, उसमें कुछ नहीं मिला, कोई नहीं पाएगा।
चलिए बहस करेंगे।
Number 10.1.
हाँ पिल्लई साहब,
Serial number 10.1 Sri J.K. Pillai.
वो फाइल की तलाश में है। हैं? हाँ ठीक है। हाँ।
I was before Aadha could.
तो क्या हो
My
गया?
engineer has kept the file as is. इसमें सर वो पिछली बार आपने बोला था कि डॉक्यूमेंट्स फाइल करने to substantiate that there was 20 employees in the organization.
कहाँ है वो?
And we have filed it.
बताइए, दिखाइएगा वो डॉक्यूमेंट, दिखा दीजिए। कब फाइल किया आपने डॉक्यूमेंट? 27/23 को।
उसमें हमने उनके एस्टेब्लिशमेंट की लिस्ट भी लगाई है जिसमें एस्टेब्लिशमेंट की खुद प्रोपराइटर ने साइन किया हुआ पूरी लिस्ट को।
पार्ट टाइम अकाउंटेंट भी शामिल होगा?
हाँ सर।
हैं?
जी। Anybody who is working in connection with the work of the establishment is covered under section 2F of the Act.
लीजिएगा भाई, एम्प्लॉइज प्रोविडेंट फंड एक्ट लीजिए। देखिए जूनियर को बुलाइए, इनको बुलाइए। क्या शुभ नाम है आपका? क्या शुभ नाम है?
सर विवेक राणा।
विवेक राणा साहब, ऐसा है, एक सिद्धांत बना लीजिए, जिस कोर्ट की फाइल है वहाँ फाइल छोड़िए, सीनियर को घूमने दीजिए। जब सीनियर आएंगे तो उनको फाइल मिल जाएगी, वो उनको आपको ना ढूंढना पड़े। मेक इट अ प्रिंसिपल। एंड आई वाज अ जूनियर, आई यूज्ड टू डू दिस थिंग। 11 नंबर कोर्ट की फाइल है, मैं 11 नंबर की फाइल पीछे रख के जिस कोर्ट में काम है उधर चला जाऊंगा। ठीक है, ध्यान रखना। अरे ठीक है, ठीक है, आपके बताने और हमारे बताने में कुछ तो फर्क है, नहीं है? हाँ 2F।
Sir, may I read section 2F of the Act?
हाँ बढ़िया।
Employee means any person who is employed for wages in any kind of work.
कहाँ पढ़ रहे हैं?
ये 2F, section 2F of the EPF Act 1950.
हाँ, डेफिनेशंस में
Definitions में 2F.
एक्सक्लूडेड एम्प्लॉय,
ना, उसके
ऊपर कंटिन्यूअस सर्विस।
ये है सर 2F employee definition 2F में है। EPF Act सर
ये किताब में कुछ अलग है, देखिएगा जरा।
नहीं, Employees Provident Fund Act देख, स्कीम देख रहा हूँ। ये स्कीम है
अच्छा सर,
फर्स्ट एक्ट में है। F. I read sir. Act में employee is defined.
जी।
2F employee means any person who is employed for wages in any kind of work. Any kind of means he may be a part-time also, but he will be an employee, manual or otherwise, in or in connection with the work of an establishment. This is important that if he is working in connection with the work of an establishment, he is covered under the ambit of section 2F of the Act. So even the loaders who are loading the cylinders in the truck, getting the payment directly or indirectly from the establishment are also covered under that. Therefore, even the contractual employees is covered under that.
J.K. Pillai, learned counsel for the petitioner. None for the respondents. Respondent number 1. This petition is directed against order dated 28th February 2005, passed by the respondent number 2, Employees Provident Fund Appellate Tribunal, New Delhi, in ATA number 263 within bracket 8/2000, Messrs. Mittal Gas Company versus RPFC Jabalpur, by which tribunal has allowed the appeal preferred by the respondent number 1, Mittal Company, challenging the orders passed under Section 7A of the Employees Provident Fund and Miscellaneous Provisions Act 1952. Full stop. It is submitted that the tribunal has held that there was no material on record to show that respondent number 1, Mittal Gas Company, had employed 20 or more persons, and the provisions of the Act will be applicable. Next para. Shri Pillai has brought on record list as was furnished by the proprietor of the Mittal Gas Company, along with IA 9509 of 2023, an advance copy of which was furnished to Shri Anup Nair, Advocate. Full stop. In this list dated 30/11/91, Shri, the proprietor has given list of 20 employees who were working as on 30/11/91. Full stop. This list was cleverly suppressed by the respondent number 1 before the appellate tribunal, and on that ground impugned order dated 28 February 2005 came to be passed. Full stop. Next para. It is submitted that
This was the initial document by which the establishment were covered under the provisions of the Act.
full stop. It is submitted that the tribunal erred in not considering the 3 loaders as the employees of the establishment of the respondent number 1 and treated them to be employee of some other establishment. Full stop. It is pointed out that in unequivocal terms, respondent number 1 had himself furnished list of 20 employees, including 3 load laborers, showing them to be employees of the Mittal Gas Company. Therefore, tribunal erred in passing impugned order. Reliance is placed on the definition of employee as given in section 2 within bracket small f bracket close of the Act of 1952, which defines within inverted commas employee means any person who is employed for wages in any kind of work, comma, manual or otherwise, comma, in or in connection with the work of an establishment, and who gets, comma, his wages directly or indirectly from the employer. Full stop. Next para. It is submitted that in the definition itself, person employed by or through a contractor or in connection with the work of the establishment is included. Full stop. Thus, it is submitted that since respondent number 1 will not be had itself furnished a list of 20 employees, impugned order is liable to be set aside. Next para. After hearing learned counsel for the parties and going through the record, I am of the opinion that learned tribunal erred in construing the definition of the employee as given in section 2F in the correct perspective and has passed the impugned order treating 3 loaders to be not an employee of the respondent number 1 institution. This finding being contrary to the definition of employee cannot be sustained.
ऑब्जेक्शन तक ही आपको 42 फाइल करना पड़ेगा सेकंड एप्लीकेशन की जगह।
Petition is allowed.
आपने क्या
फाइल
किया?
439(2) उसमें connected matter में क्या किया?
डिस्प्ले इन वांट ऑफ प्रोसिक्यूशन।
Petitioner has filed, applicant has filed an application under application IA number 7816 of 23 for conversion of his application into an application filed under, into a petition filed under section 482 of Code of Criminal Procedure, full stop. For reasons stated in application, IA is allowed. Necessary corrections be made in petition within period of 2 weeks.
Page 46 is the order passed by the collector of Istanbul.
46.
46.
Yes.
MCRC dismiss हुई है warrant of prosecution 1/9/2022 को।
1000.
One Malord Lupin Laboratories Limited company has been,
क्या है? एक सेकंड बताइए, समझाइए।
इसमें एक Lupin Laboratories Limited company थी
None
that has been
appears
amalgamated
dismissed.
to the Lupin Chemicals Limited by the order passed by the Bombay High Court. Malord. Then Malord,
The limited prayer is that my application seeking supportigi of certain
there
amounts
was
have
a
been
five,
dismissed by both the courts below.
क्या amount है?
23
lease
lakhs.
agreements in respect of
Some
that.
amount.
तो हर पांचों
Yes.
लीज एग्रीमेंट के आधार पे
So what is the reason for
was
dismissal?
that investigation was not
the
completed. Now
office of
investigation is being
महानिरीक्षक
completed. Charge
पंजीयन
sheet
मध्य
has been
प्रदेश
filed.
भोपाल
So you can file fresh
कि
application there.
इसका एमलगेशन हो गया है और इसको जो
Change
है
circumstance.
इसमें प्रॉपर स्टैम्प ड्यूटी इसमें हाँ नहीं दी
No,
गई।
how I can appreciate these
under,
change circumstances?
section
Kindly
47
appreciate, it is not the only the change in circumstances. The
they are
reason
liable
which is
to
being
pay
given,
the
my lord,
stamp
kindly
duty,
appreciate the
Malord.
order.
So what is the ground? Change circumstance
47
or?
No, Lord, it is not. The ground is that the order passed by the both the courts below perverse in nature. It was not required. There is no
along
provision
with
in
Malord,
the
Let's see what is your grounds.
there was an amendment
क्या ground
also.
लिया आपने?
So as per amendment, the collector of Istanbul has held that
My lord, kindly
that
appreciate
amalgamation
during
of
the
the
course
company
of argument
is
the fact regarding income tax no objection certificate
reject,
has not been
transfer.
produced before the
is a
trial.
convinced
Now when the charge sheet has
and
already been
therefore
filed, I
they
have
are
filed an
liable to pay the
application seeking
stamp
document
duty.
taken on
Stamp duty.
record.
Yeah,
My lord, may
this is
kindly
the finding
appreciate my
which has been
application
recorded by the
in the
collector
present
of
case,
Istanbul, Malord.
the document taking
जी,
record.
फिर इसमें
Page
क्या बोर्ड ऑफ रेवेन्यू ने क्या
Now
कहा?
income
इसमें
tax has also given me the
फिर
NOC and
कमिश्नर
it
ने
is the
उस
part
ऑर्डर
of
को
the
एफर्म कर
charge
दिया
sheet.
जी जी
फिर बोर्ड ऑफ रेवेन्यू ने क्या किया certain issue has been framed and
Where is impugned
they
order?
have said that
My lord,
it
may
is
kindly
not
appreciate
a
it is at page
conveyance
10.
बताइएगा कहाँ है वो उतना
Relevant
पढ़
is
के
at page
बताइए।
11.
So you have not given a single reason why order is bad in law.
My lord, we say that, my lord, may kindly appreciate our grounds.
वो क्वेश्चन ऑफ ला फ्रेम किया
आपने कुछ
Malord
नहीं
is
कहा है order
it
के
is
बारे
at
में।
page 9
My lord, may kindly appreciate the lady applicant who is before your lordship and who was before the trial court.
Yes.
She has nothing to do with the crime. It was the son who was being implicated. My lord, may kindly appreciate ground number C.
Why order is bad? ये
The
बताइए
order
ना।
because it
the
was not
following
considered.
questions of law
This
कहाँ
arise
लिखा है
arise
आपने?
for the consideration
कहाँ आप
Lord,
बोर्ड ऑफ रेवेन्यू का ऑर्डर पढ़ रहे हैं?
जी
The
बोर्ड ऑफ रेवेन्यू का है
investigation,
इंटरनल पेज
it is not,
इंटरनल पेज
though it is
Malord
इसने order का तो
9
कहीं
9
attack ही नहीं किया है।
Lord, my
Nine
entire
उसमें
case
You
is
have
that
not challenged
Friend.
anywhere
Sorry,
why
Malord.
order is bad. Only grounds you have mentioned.
ground number A,
चौदह,
A
15.
contains it that it
पंद्रह.
this
पंद्रह
order
पेज
is
है,
not
very
valid.
पंद्रह
A, B,
Bad
C.
in eyes of law.
The
Malord,
following
A, B,
questions
C,
of
D
law
reasons
arise for
for
the
there are
consideration
reasons.
of this
The
court.
lady has nothing to
Number one,
do with
whether
the
the order of the Bombay
Order
High Court
बताइए,
passed
where
under
is
section
order?
394
Order is at
of
page
the
10.
Companies Act 1956
Relevant is at page 11.
भी निकाल लीजिएगा अभी नया
11
वाला
is
मत
the
निकालिए
relevant part.
56
केस डायरी का अवलोकन किया गया जिससे दर्शित होता है कि
1956
आरक्षी
falls
केंद्र
within the
ओमती के
term,
अपराध क्रमांक 271/22
conveyance as defined
अंतर्गत
under
धारा
the
4
Indian
का जुआ
Stamp
एक्ट
Act
व
in its
120 भारतीय
application
दंड विधान के
to
अधीन
state
उक्त
of
रुपए
Madhya
जब्त
Pradesh
किए
prior
गए
to
हैं।
the
थाना ओमती की
amendment
ओर से प्रस्तुत
coming
प्रतिवेदन में
into force
सनपाल
with
गैंग का
effect from
सदस्य
30th
अजीत गोगा व
August
उसका भाई आकाश
2002.
गोगा अपने फ्लैट
Number
मुस्कान
two,
हाइट नेपियर टाउन पर सट्टा
whether
खेलने
stamp
वालों का
duty
पैसा
under the
इकट्ठा
Madhya
रखते
Pradesh
हुए थे
Stamp Act
जिसे
as
मुखबिर सूचना के
it
आधार
is
पर
to
ओमती
prior
पुलिस
to
द्वारा
the
कार्यवाही कर
settlement
रुपए
is
जब्त
payable
किए
on
गए
the
हैं तथा
pro
प्रकरण में
market value of the
अंतरराष्ट्रीय स्तर का
immovable
अपराधी
property
सतीश
located
सरपाल
in
की
the
पता
state of
तलाश
आप
की
क्या
जारी
करेंगे इस पैसे का?
whether the successor of Lupin
What you will do with this money?
laboratory is
Well,
limited.
अगर आपको
Is
ये
entitled
सुपुर्दगी
to
पे
assume all
मिलेगा,
the rights with the
you
original
cannot
lessee
deposit
involved
it in
since
bank,
the
nor you
appeal
can use it.
the transferring
क्योंकि
company
ये तो
has
एविडेंस है,
become
उसमें नंबर है, जब्ती के नोट हैं, वो अब लास्ट में लगेगा
main
मिलाने के
First
लिए.
issue, charge sheet has been
Yes,
filed.
main
issue के बारे में
क्या
क्या
आप करेंगे कि अपने लॉकर में रखेंगे ना, और तो कुछ कर ही नहीं सकते हैं.
kindly appreciate, my lord.
भाई आप ना वो किसी को दे सकते हैं ना बैंक में जमा कर सकते हैं, क्योंकि वो नोट जब कोर्ट ऑर्डर करेगा यू हैव टू प्रोड्यूस इट एज इट इज. तो आप क्या करेंगे अपने पास लेके इस नोटों का?
of the act prima facie so that its paramount object to facilitate
आपने तो
reorganization of the
कुछ भी
companies
नहीं कहा.
through
You have not said anything
amalgamations,
about order.
mergers and the like. The section expressly provides that the order passed by the court sanctioning the scheme has the effect of vesting the property in the
No,
amalgamated
that will be
company
required कि
without
ये
any
वही
instrument of
नोट हैं
conveyance
जो
or a
पुलिस
deed.
ने जब्त किए थे.
Thus the transfer takes effect
For a
by
public gambling
operation of
act,
law
even if I
and
am
not by
I am being
act of
punished,
parties. Conveyance of the
maximum
property is
sentence, my
constitutional
lord, may kindly
to
appreciate
the
it is
court
the
of the
only 1,000 rupees
to
fine.
the order of the
पैसे का क्या होगा जो सीज हुआ?
Companies Act का section
They
394
in the investigation, my lord, they have not said anything regarding this amount, my lord. Income tax has given me the NOC that this is audited amount. And in their charge sheet, it is the part also. My lord, may kindly appreciate, I have filed an application for taking document on record. हमने दो दस्तावेज प्रस्तुत किए गए हैं. इनकम टैक्स विभाग ने ये कहा है कि हमें कोई आपत्ति नहीं है ऑडिटेड अमाउंट,
हाई कोर्ट का ही
और ये
डिसीजन
इनकी चार्ज शीट का पार्ट है.
ये
So
हमने
जहाँ
पेज
तक प्रश्न, as
78
your
पे
lordship has
लगाया
has observed that these
उसमें सब डिस्कस कर दिया
amounts and notes
points
would
को
be
discuss
required to tally. There will
to
not be any
determine
trial, my lord. I'll be appearing and I'll be confessing it. And maximum punishment is 1,000 rupees.
Such person as are
तो आप
mentioned in
कन्फेस
this
कर
section
लीजिए, ले लीजिए पैसा.
shown to the
Kindly
chairman of the
appreciate
company.
that stage has not arrived, my lord. My lord, this order has nothing to do with my I am Rajni Goga. I'm the mother of the accused.
That,
and this money belongs
that
to
इस
section has
ऑर्डर
been
में
discussed.
what's wrong in this order? आप
This is perverse, my lord, because it
कहाँ
has not
perverse
been
है?
considered, because the role of the lady has not been considered. I have nothing to do with the crime. And this, I am filing the application seeking supurdagi of these amount, saying that this belongs to me. And order nowhere speaks about this. कि रजनी गोगा की क्या भूमिका है? The mother of the applicant.
Who is accused in the case?
Akash Goga and Ajit Goga, son of the lady. So the perversity.
And it is seized from your house.
It is seized from सट्टे की. Yes, ma'am.
ये कहाँ से सीज हुआ है?
मतलब डायरी नहीं है हमारे पास.
डायरी अब तो चार्जशीट पेश हो गई अब तो इसमें.
डायरी तो हमारे पास होना चाहिए.
अच्छा.
Government advocate appearing for state praise for some time to call for case diary after 2 weeks.
मतलब मैं keep it during the course of next week, मतलब काफी दिनों से पहले.
After 2 weeks.
मतलब any week commencing.
Week commencing.
Hello. This is 482 petition for the simple direction, my lord. The applicant has been convicted, my lord, three cases for the offences under section 457, my lord. My limited prayer is that it's like a mercy petition is also, my lord. All the sentence had been running concurrently, my lord. That's why I filed this petition, my lord.
Concurrently?
My lord.
क्या है? What is the provision?
Under section 427 of the CRPC, my lord.
Yes.
The court has power to, my lord, passing these orders. All the sentence has been.
पढ़िए.
Sentence of offender already sentenced for another offences, my lord. When a person married one? Married?
Yes.
When a person already undergone a sentence of imprisonment and the sentence for the subsequent conviction is imprisonment for life, such imprisonment or imprisonment for life shall commence at the expiration the imprisonment to which he has been previously sentenced, unless the court directed the subsequent sentence shall run
How
concurrently.
direction can be given? How court can give direction?
Although so many judgment have been passed by the Honorable Apex Court in the 138 cases, my
हाँ
lord.
बताइए ना कहाँ है?
This is the, my lord, the
If there is no direction by trial court, then it means that it will be run one after other. तो ये तो मान ही जाएगा कि ये
वो जेल नियमावली में जो प्रावधान है उसके हिसाब से होता है सर, उसमें जो प्रावधान
then
दिए
तो कोर्ट कैसे डायरेक्ट कर सकता है?
but the court has the
Trial
power
court
to
will
direct
have
to the
intended-
jail authorities, my lord. In the case of the VK Bansal versus State of Haryana 2013,
तो आप अपील में चैलेंज करिए कि ये गलत है, इसमें ये इनको कंसीडर करना चाहिए था। Why 482?
the appeal has already been dismissed and revision has also been dismissed by this
अब
honorable
क्या,
court.
अब तो इसमें 482 में कोई स्कोप नहीं है।
That's why I filed this petition only for simple direction for the
That cannot be done. आपने उसमें अपील में ग्राउंड लिया था क्या?
नहीं।
कहाँ
I
से
had not
डिसमिस
taken
हुई है?
रिवीजन भी हाई कोर्ट से डिसमिस हो चुका। 457 का था जेएमएफसी ट्रायल का केस था।
अब क्या होगा? कुछ नहीं होगा।
But under the 138 वाला तो सुप्रीम कोर्ट has passed so many order, my
filed
lord.
this petition under section 482 of Code of Criminal Procedure for issuing of direction that
The
sentence awarded
page
by
78.
the trial
My
court
lord, page
be
78.
directed to run concurrently. Full stop. It is submitted that no direction has been given in
That is the
judgment passed by the trial court. Full stop.
page 77, 78.
20 कौन सा
It
जजमेंट
is submitted that this court
AIR
has inherent
2004,
power
yes,
to
CT
issue directions to
326.
trial
जी,
court to
जी, जी।
secure the ends of justice or
लगा हुआ है, रहने दो उसमें लगा हुआ है।
or to save
Para
or
44
for
and 45.
Yes.
from miscarriage of
लिखिए।
justice. In which circumstances petition be allowed. Government advocate appearing for state opposed the prayer and submitted that if petitioner has some grievance against the judgment, then petitioner ought to have challenged the same in appeal. Appeal filed by petitioner has already been considered and was dismissed. Revision was also dismissed by the High Court. In all these proceedings, petitioner has not raised any ground that judgment passed by trial court. Direction ought to have been given by trial court that
These petitions are
sentences will
filed
run concurrently.
by the
Stop.
state
Now High
being
Court
agreed of
exercising its inherent power
common
cannot
order
issue any such
dated
directions. Heard the counsel for the parties,
23/7/2004
section
passed
427
by
of Code of
Learned
Criminal Procedure
Board of Revenue
1973 is reproduced
MP
as
Gwalior
under. As
in
per said
appeal
section,
numbers
if no direction is given by the trial court
/1/004
to run the sentence concurrently, then
878
sentences will run one
/1
after other.
/04
Full stop. In this case
decided
also
by
no direction has been
common
given
order
by the
dated
trial court
31st
to
March 2004
trial
passed
court.
in
No direction has
appeal
been given by
numbers
trial court that sentence will
28
run
to
concurrently.
32
In absence
by
of
the
such
learned
direction as per section
by the additional
427,
commissioner
sentence
Bhopal
will run
Hoshangabad division
subsequently, that
Hoshangabad
is one
Bhopal.
after
Next
another.
file.
No
Brief
grounds has
facts
been raised in
leading
appeal
to
and
the present
revision.
case are
Revision and appeal
that
has also been
Lupin
dismissed.
Laboratories Limited,
And now at this
herein
stage, this
after
court
referred
cannot
to as
interfere
a
in
transferor
the
company,
judgment passed by the trial
sought
court exercising its
amalgamation
inherent power under section
of
482.
its facilities
Considering
with
aforesaid, petition is
Lupin
dismissed.
Chemicals Limited within bracket, a transferee company, full stop. An application was made to
None
the
appears.
company
Dismissed
judge
for want of
and
prosecution.
the scheme of amalgamation was approved by the High Court of Bombay.
The High Court of Bombay.
High Court of Bombay by order dated
My lord, this 482 has been preferred against the order dated 15/5/23, my lord. In fact, my lord, we are seeking for a bail, my lord, with regard to the, under the provision of 437(6), my lord, the bail application was filed before the trial court.
Yes.
And in fact, my lord, that has been rejected. Against that, my lord, we preferred and that is, my lord,
sorry,
it would be a
High
revision,
Court
my
of
lord, in
Bombay
fact,
by order dated
challenging the
13th
order
June
of
2001.
437(6) passed by the
Full
magistrate.
stop. The said
That has
scheme
been,
of
my lord,
amalgamation
rejected. In fact, my lord,
as
after a
approved
period
by
of
the
60
High
days,
Court
my
of
lord, as
Bombay
envisaged in
came
the
into
provision of
effect
437(6),
with effect
that,
from
from
July
the date of
2001.
evidence, my lord, the
Full
trial
stop.
should have been concluded, but
Consequent
it
to
is not
said
concluded
amalgamation,
till today. So, my lord, we
transferor
are trying for the
company,
bail, my lord, on
that
this
is
ground, my lord. In fact, the
Lupin
accused person was
Laboratories
having a
Limited,
criminal record, that's why my lord has rejected
merged
the
in
bail
the
application,
transferee company,
the regular bail
that is
application long
Lupin
back, my lord.
Chemicals Limited,
But we are passing it
and a
on
new
the
entity came
437(6)
into being.
provision, my lord.
क्या है
Full stop.
437(6) within
The
period of
issue
60 days?
which
Yes, yes, my lord.
ये mandatory है क्या?
full
Yes, my
stop.
lord, it is
Next file.
mandatory and most of
The
the
collector
It
of
is not
stamps
mandatory.
my lord, but all the offenses, my lord, I just
Raisen,
as far as
Raisen
possible,
held
ऐसे
that
देखिए,
मैं just
in terms of
my lord, it is no, my
the
lord,
definition
I was just
contained
reading out.
in
If
Yes.
if in any case triable by a
section
magistrate, the trial of a person
2 within
accused of
bracket
any
10
non-bailable
of
offences
conveyance
is not concluded within the
as
period of 60
contained
days
in
from the date fixed for taking evidence in
stamp
case,
state
such
stamp
person
act,
shall, if he is in
comma,
custody during the whole of said period, be released on bail to the satisfaction of the magistrate, unless for the reason to be recorded in writing, the magistrate otherwise shall direct. So, my lord, it is
and
direct. There is
instruments
a,
of
my lord, there is such
amalgamation
person
being
shall,
covered by
if he
that
is in custody, my
entry,
lord.
comma, as as entry number as article 23,
unless for the reasons
comma,
to be recorded
stamp
in
duty
writing,
will be
magistrate ने
payable
reasons दिए हैं.
No,
on
my
the
lord, in
scheme
fact, I
of
have filed the order
amalgamation
of the
between the
revisional court
transferor
only.
and the transferee companies.
Magistrate का order कहाँ है?
Accordingly,
Sir, मैं इसको
collector
फाइल कर
of
देता हूँ,
stamps
नेक्स्ट वीक करते हैं.
passed order
Counsel
dated
appearing for
they issued a
petitioner
show
pays
cause
for
notice dated 7th
adjournment
June
after 4
2002
weeks.
My lord,
under
I'm
the
just,
provisions of Indian
my lord,
Stamp
3
Act
days time, because my lord,
1899
it is unnecessary.
requiring both
next
the
week,
companies
after
to show
1 week.
cause
That-
for the
Yes,
purpose of levy of stamp duty
डायरी
on
की क्या
conveyance
जरूरत है?
at the fair market value. Full stop. Next para. Admittedly,
Only it is to be seen
reply
whether
was filed
magistrate
to
has
the show
assigned
cause
any
notice
reason. If reason is
protesting
there,
the
then it
levy
is
of the
within its
stamp duty
jurisdiction.
My lord, where, because the coordinate bench
and
has
thereafter
Revision में भी लिखा होगा,
and
पढ़िए
pointing out
revisional
that
court का order.
since the amalgamation has been sanctioned
in
by the
revision, my
scheme
lord,
of a court,
it has
therefore no
been
court stamp duty will be payable.
stated that कि
Full
earlier
stop.
the High Court had dismissed the bail application.
Collector of
मैं पढ़
stamps
देता हूँ order, my lord. Page number 10, my lord.
While its order dated
And that is, my lord, जवानत आवेदन पर अभियुक्त को सुना गया, न्यायिक दंड अधिकारी प्रथम श्रेणी सो एंड सो का अवलोकन
22nd
किया गया,
August
जिससे दर्शित है
2003
कि घटना दिनांक
directed
15/7/22 के
for
परिप्रेक्ष्य में
valuation
उक्त
of the
दिनांक को
land,
वार्षिकीन सो एंड सो में प्रथम
building and
रिपोर्ट
machinery
लेख की
to be
जाकर
carried
आरोपी को
out
दिनांक
while
1
it's
8/8/22 को
to be
गिरफ्तार
carried
किया
out.
जाकर
Full stop.
18/10/22 को
Thereafter,
अभियुक्त प्रस्तुत किया
collector
गया,
of
जिसमें आरोपी
stamps
गिरफ्तार की
directed
दिनांक
the
से ही न्यायिक अभिरक्षा
appellant
में
to
है.
pay stamp duty and
आवेदक
registration fee
युवराज सिंह द्वारा
amounting
सह
to
अभियुक्त सो एंड
rupees
सो के साथ my lord, these
4
are the
lakhs,
prosecution case की
sorry,
what
4
has done.
crores
And my lord,
88
जहाँ
lakhs
तक ये operative court at page number 11, my lord,
3,507.
page number 5 on the next page.
Full stop.
जहाँ तक दंड प्रक्रिया संहिता 437 के प्रावधान का प्रश्न है, तब यह संबंधित न्यायिक
Since
मजिस्ट्रेट को उपरोक्त प्रावधान के तहत
respondent
आदेश
had
पारित
deposited
करना
a
आवश्यक
sum
है,
of
किंतु
rupees
आरोपी को
875 with the
जमानत प्रदान किया
sub-registrar, therefore
जाना का ही
sub-registrar
आदेश
ordered
दिया जाना
for
आवश्यक नहीं
payment
है.
of
उक्त आदेश के परिप्रेक्ष्य
balance
में
sum
संबंधित न्यायिक मजिस्ट्रेट
of
आरोपी के
stamp
विरुद्ध
duty. Full
आक्षेपित
stop.
आरोप की प्रकृति, उसका पूर्वतन आपराधिक
Next
रिकॉर्ड
paragraph.
एवं प्रकरण में विलंब
This order was put
किसके
to
द्वारा कार्य
challenge
की
by the
उपरोक्त सभी बातों
respondents
को विचार में ले
before
सकता
the
है. इस
additional
संबंध में सो एंड सो
commissioner
है. And my
Bhopal
lord,
/ Hoshangabad
उपरोक्त न्याय
division,
दृष्टांत नेक्स्ट पेज, my lord, कि
which
मैं प्रतिपादित
while order
के
dated
आलोक में
31st
प्रकरण का
March
अवलोकन करने से
2004
दर्शित है कि भले
upheld
ही
the
आरोपी
orders of the collector of stamps
विरचना के
against
पश्चात
which
साक्ष्य नियत
said
किए जाने
appeal
के
is
60
filed.
दिवस के भीतर
Appeal was
अभियोजन
filed
संपूर्ण
before
नहीं
the
हुई
Board
है,
of Revenue.
किंतु
Full
आरोपी के
stop.
विरुद्ध गंभीर प्रकृति के अपराध हैं.
Learned Board of
उसके
Revenue,
विरुद्ध समान प्रकृति के अपराध
after
का
making
ही निम्नतर
discussion of the
आपराधिक
facts,
रिकॉर्ड भी प्रकरण में
held
संलग्न है, जिसका आपराधिक
that
स्वयं है.
since
फलतः
order passed
उपरोक्त
by
सभी
the High
तथ्यों को
Court
दृष्टिगत रखते हुए
under Section
आवेदक द्वारा
394 of the
आवेदक धारा 437
Companies Act
दंड प्रक्रिया के तहत
1956,
भी जमानत प्राप्त करने का अधिकारी
sanctioned the
प्राप्त
scheme of
प्रतीत नहीं
amalgamation,
होता. अतः आवेदक की ओर
it
से
cannot be
437 के आवेदन के
considered
विरुद्ध
as a
धारा
conveyance,
439 के तहत
conveyance inverted
प्रस्तुत
commas
आवेदन
में
निरस्त किया
लिखिएगा.
जाता है.
Since there was no specific entry in the Madhya Pradesh
My lord, in
Stamp
fact,
Act
no
prior
finding with
to
regard
the
to it
said
has been given.
amendment,
Only
and
reiterating the
it,
criminal record. This application has been rejected.
accordingly,
So,
the
my lord,
Board
the
of Revenue
period,
had set
in fact, my
aside
lord, this
the
is the order
orders
of a
of
coordinate
the
bench where
collector
is
of
also, my lord,
stamps
it
and
is a matter
that
of excise where the similar cases were registered of about
additional
10 to 8
commissioner.
cases, my lord, with
Next
regard to
paragraph.
the excise. The
The
coordinate
moot
bench, my lord, this is a
question which is
2019
involved
order
in the
passed by
present
Honorable
case
Station,
is
that is
that
R.K. Dubey, my lord,
what was the
wherein it has
definition
been
of
observed and
conveyance
holding that
prior
if
to
trial is not
amendment
concluded,
being
then, my lord, the accused
incorporated
be given the
in the
benefit of
Indian
bail,
Stamp
exercising
Act?
the power
Full
under
stop.
437. 1976.
या तो उसमें जिसमें पनिशमेंट कम होता है,
this is also
एक साल तक का पनिशमेंट होता है.
Petitioner has filed this petition under section 482 of Code of Criminal Procedure for grant of bail to the applicant. It is submitted that applicant is entitled for grant of bail under section 437(6) of Code of Criminal Procedure 1973. It is submitted that
Prior to the amendment,
provision is mandatory in nature. In these circumstances, applicant be enlarged on bail. Government advocate appearing for state opposed the said prayer. It is submitted
लिखा है Board of
that
Provisional
application
Declaration को?
was dismissed by
नहीं लिखा होगा.
judicial
हैं?
magistrate first class. Thereafter, revision was filed, and revisional court has also dismissed the application, relying on judgment passed in case of Devraj Maratha versus State of MP, reported in 2018
पुराना
SCC
edition होगा.
online MP 51. In said case, it has been held that
amendment लगाया है
section 437(6) is mandatory in
Amendment
nature,
आपने लगाया है?
and magistrate is required to exercise his
Page
power for
71.
granting bail
71.
after statutory period. But said provision does not say that bail is to be granted to the accused person. Magistrate has passed,
इसमें state
revisional court
पुलिस
has
पर क्या
passed
है?
well-reasoned order, and there is no reason for interfering in
इसमें
order
यह है कि
dated
उस संपत्ति के जो कि
15/5/23.
हस्तांतरण पत्र की
Petition
विषय
filed
वस्तु
by
है बाजार
petitioner
मूल्य
is
का
dismissed.
8%.
My lord, I
एक
place
साल हो
reliance
गया
on
है.
this, my lord, this judgment may kindly be referred, my lord, to the coordinate bench.
Suspended.
Magistrate, yes, there is only consideration is required.
My lord, in fact,
He
this
can
is the order.
reject also by giving
My lord,
reasons.
this is the order whereby Honorable Justice R.K. Dubey having the same, my lord, 5 bail application was rejected in the matter of
ये
excise.
कहाँ का है ये?
Sir, अपनी bench का है.
इसमें सुप्रीम कोर्ट का ऑर्डर लिखा हुआ है, कंसिडर्ड हो गया. यस, नेक्स्ट.
Page number 50, Supreme Court.
Page 71 पे क्या लिखा है?
जी इसमें ये
ये ऐसे आधी अधूरी डेफिनेशन से थोड़ा ना काम चलेगा वकील साहब.
My lord, this is the same matter, my lord. Last week, my lord had said that we need to make the
इसका पुराना
private
एडिशन
respondent
लीजिए ना
also a
MP
party.
लॉस का.
Yes.
Already moved an application, my lords, for
Fourth
pleading him as a
edition
party.
IA number
That is, my lord, IA number
17079 of 23 is allowed.
15 में.
Necessary correction be made within
Second
1
edition
week.
दीजिए इसकी.
If necessary
यही होगी
correction within period of 3 days.
किताब. देखिए.
If necessary correction is made within 3 days, then notices be
47
issued to said respondent on payment of PF within 7
My lord,
days.
still then, my only prayer would be, last week also I had
Collector
requested
of
my
stamps
son
का
was
order कहाँ
seeking
है?
a
Page
court
number?
Notice
action.
is
Page
made
number
returnable
46.
within period of
46.
7 days. What is the ground
My lords, the ground is, if my lord will just come to my lord's page 20 for a moment of the petition.
of
Of
petition?
the, of the petition, my lord.
Yes.
My lords, this is the registry, my lords, dated way back in the year 2004. My lords will see the parties, my lords. It is between technocrat developers and my lords, one Mr. Devendra Kumar Gagodia.
Page 20.
20, my lords.
20 is annexure.
My lords, annexure A1.
Petition तो 16 तक है.
Annexure, my lords.
Yes.
Annexure. I'm so sorry, my lords. Annexure A1, page 20.
Yes.
Now, my lords will just find, my lords, I am the purchaser, my lords, technocrat developers. And my lords, I have purchased this property from Devendra Gagodia and my lords, his brothers.
Anil Sethi.
Anil Sethi, my lords, is the present applicant, who is
Yes.
the director of technocrats.
Yes, yes.
Now, if my lords will just come to page 21 for a moment. my lords.
Yes.
Now, my lords, these are the property descriptions which I have bought, my lords. The khasra numbers are written.
Yes.
Khasra number 651, I have never purchased.
Yes.
Now, if my lords will see, this is the registry in the year 2004. If my lords will just come to page 51 for a moment, my lords.
Annexure.
That is A5, page 54, my lords. A5.
Yes.
In the year 2008, my lords, I complete the entire project.
Yes.
I am a developer. I complete the entire project. I get a completion certificate also.
Yes.
Now, my lords, subsequently, my lords will just come
Conveyance
to
is defined in section 2
Annexure
within
A10,
bracket
page
10
64.
of the
Yes.
Indian Stamp Act 1899,
Private complainant, my lords,
and it
approaches the
includes a
Tehsildar
conveyance
and
on
says
sale
that on his
and
651
every
khasra, there have been some
instrument by which
encroachments. I have not been made a
property,
party.
whether
I am the
movable
developer. I have not been made
or
a party.
immovable,
Now,
Some
the-
other
comma, is
persons has made
transferred
encroachment.
My lords,
inter vivos,
what he says before the
and
Tehsildar
which
is
is
that the
not
colony that has
otherwise
been developed, the people
specifically
living in the
provided
colony
for
have encroached upon my
by
land, the
Schedule
complainant's
1.
land.
Full stop.
Now, my lords, what the
Next
So
Tehsildar,
you have handed over the possession
Schedule
we
of
have
the
one.
handed over
colony.
in 2008, my lords.
दे दिया आपने possession.
Possession 2008 में दे दिया, registries हो गई
Now
8
it
में.
is in under municipal corporation.
Now it is under municipal corporation.
Petitioner has filed this petition. Council appearing for petitioner made a prayer.
My lords, it is with the municipal council Panagar, my lords.
Made a prayer that interim relief of no coercive action, that is arrest of petitioner, be passed in the case full stop, it is submitted that no case under section
was admittedly
420
amended
and 448, Madam Chair.
420
in the state of Madhya
And-
Pradesh.
448 of Indian Penal Code is made out
ये
against the
फिर और
applicants.
amendment हो गया है भाई.
It is submitted that
इसके पहले वाला volume
applicants
चाहिए.
are it is submitted that applicants are developers and
भाई.
colonizers,
ठीक है ना?
and they had
तो यहाँ
developed the
बीच में छोड़िए
colony
ना, फिर उसके बाद लिखिएगा.
on the land purchased by them
Supreme Court in
after
case of Hindustan
completion
Liver
of development.
and
Whole
another
property
versus
has
State
also
of
been sold
Maharashtra
to
and another
individual customers.
AIR
Completion
2004
certificate has
SC
also been
326
obtained and
had
possession
an occasion
and
to deal
now
with
colony is under Municipal Council Panagar. Full stop. After development of
this
colony,
aspect of amalgamation of
people
companies
living in colony
levy
has
of a stamp
encroached
duty
upon Khasra number
on order of
651.
court sanctioning scheme of
Full stop.
amalgamation.
Applicant does not
Full
have
stop.
any role on it.
Supreme Court
In these circumstances,
held that
applicant be protected. Full stop. Notice तो हो ही गया ना. Considering aforesaid circumstances of the case, Police Station Panagar, Jabalpur MP is directed not to arrest applicant number 1 till next date of hearing.
And my lords,
List the matter after service of notices.
my lords, and no further coercive action, my lords, because they are summoning us every day, my lords.
नहीं तो हो तो गया, they will not arrest you. But I cannot stop them from investigating the offense.
My lords, they have taken my statements. Everything is done. Now what they are saying is the other partners of Technocrat, we will make them also a party. That is the harassment we are facing, my lords. That is the only reason why we are before my lords.
Call for diary.
डायरी है लॉर्डशिप,
है diary.
डायरी है. उसमें जो आदेश है न्यायालय तहसीलदार पनागर का 0.20 हेक्टेयर जमीन पर
that it is within the
From the day
competence of the state
scale this property
legislature.
तभी से उनका कब्जा चला आ रहा है. और इसमें थोड़ी फाइंडिंग भी दी, प्रकरण दर्ज किया अगर
Even if you suppose that he has taken possession, तो भी cheating कैसे हो जाएगी?
448 अट्रैक्ट होता है.
Levy stamp duty on
My lords,
court
insofar as
of
the
order
argument for 448
sanctioning
is,
scheme
that is
of
hopelessly barred by
amalgamation.
limitation.
बकायदा राजस्व में नामांतरण एवं
Full
नगर
stop.
पालिका से नक्शा पास
Since-
उपरांत जो जमीन क्रय की
नहीं,
गई थी
since the
उस
Bombay
पर
Act
निर्माण कार्य किया गया.
by
अध्यक्ष
which
कुछ भी नहीं, हाँ यदि
properties
भूखंडों में
were
कोई आपत्ति
transferred
है तो पूरी जवाबदेही कॉलोनाइजर
provided
श्री अनिल
for
सेठी की है. प्रेजेंट
inclusion of
तथा उक्त
amalgamation
प्रकरण में
scheme
समस्त जवाब
within the
अनिल
definition
सेठी से
of
लिए जाने का
instrument,
ये
अनुरोध
house
किया गया.
trespass 448 कहाँ से हो
stamp
जाएगा?
duty was payable. Full stop. In the
448 बोल
present
रहे हैं
case,
ना?
जी.
when
हाँ, तो
this aspect
448
is
is
examined
punishment for
in
house
terms
trespass.
of the provisions
That is the
contained
ground we
in
have taken in the 482.
House trespass कैसे हो जाएगा?
250 MPLR
Section 2 within bracket 14 of the Indian Stamp Act 1899,
Yes, next.
then instrument is
I am obliged.
defined to include every document by which any right or liability is, comma, or purports to be, comma,
The
created,
tractor and
comma,
trolley has been seized from the
transferred,
forest department, my lord,
comma,
in the year
limited,
2017, my
comma,
lord.
extended,
25/9/17, my lord.
extinguished, or
Under the
recorded.
forest
Full
act, my
stop.
lord.
Yes.
And alleging that the applicant, my lord, was carrying the sand from the forest area, my lord.
Yes.
Full stop.
There are
क्या what do you want? क्या relief
नहीं,
चाहिए
it-
आपको?
it-
vehicle
held
हमारी
by
my lord
the
is releasing
Gujarat
the
High
vehicle,
Court
my lord, on support nama,
in-
my lord.
The case of Chief Controlling Revenue Authority versus Nutan Mills,
Yes.
that
और
the clause refers to a document
इनका कहना है
which
कि my lord ये
itself
forest
creates
act
a right
इसमें
or liability
product है.
or purports to create a right or liability. Full stop.
So if it is
In the
involved
present
in
case-
forest offense, तो confiscation होगा by forest department.
My lord. इनका कहना है my lord,
लॉर्डशिप ये सोन घड़ियाल अभयारण्य क्षेत्र है उस एरिया का है.
Question is whether court can exercise its jurisdiction to release the vehicle. इसमें भी intimation का है ना forest department का.
my lord.
Intimation आ गया है क्या?
हाँ my lord, इस नोटिस उनको गई थी, सर्व भी हो
Since
गई है.
तो आप वहीं
instrument of
forest department
amalgamation
जाइए, वही लोग करेंगे.
is the one
Actually, my lord,
which
last
through
time
which
honorable court was pleased to issue the
right
notice to
or
the forest
liability in the
authority, my lord.
immovable
And that
property
notice has
is
been
Where is
created.
order?
And
Earlier order, my lord, on
Conveyance, definition of conveyance in section 2 within
Impugn
bracket
order
10
कहाँ है?
Impugn order is, my lord,
includes
P1 and 2, my lord.
every
And
instrument
thereafter,
by
my lord,
which
preferred
property,
revision
whether
Annexure
movable or
A1.
immovable,
A1 and
is
A2, my lord.
transferred inter vivos and which is not otherwise specifically provided for by Schedule 1, comma, the order of amalgamation cannot be treated to be not a conveyance not chargeable with stamp duty, and therefore the impugned order passed by the learned Board of Revenue being contrary to the
Page number?
judgment of Supreme Court in
Uh,
a Hindustan Liver and
40.
another Supra, comma, cannot be allowed to be sustained. Therefore, impugned order
And
is
condition,
hereby
my lord,
quashed and
42, page
petition
number
is
42.
petitions are
Para
allowed.
This order is of DFO.
Para 4, my lord.
Yes.
My lord.
ये तो आपकी कॉन्फिस्केट हो गई, अब कहाँ से सुपुर्दगी नामे पे रिलीज हो गई?
My lord. एक्चुअली मैं जो
Yes.
कॉन्फिस्केट किया गया माय लॉर्ड, वो गलत, इनका कहना है कि ये जो रेत जो है ये फॉरेस्ट प्रोडक्ट है।
You are praying for interim relief.
नहीं, नॉट माय लॉर्ड, नॉट ओनली इंटरिम रिलीफ,
हाँ।
एक्चुअली माय लॉर्ड फॉर क्वेश्चन ऑफ
आप कॉन्फिस्केशन का ऑर्डर चैलेंज कर रहे हैं
Yes, my
ना?
lord.
आपने पहले कहा you want सुपुर्दगी नामा ऑफ व्हीकल,
सुपुर्दनामा आल्सो माय लॉर्ड,
which is order impugned.
इम्प्यून is माय लॉर्ड
दीजिए, वो खिलाया
A1
भी आपके
and
पास।
A2 माय लॉर्ड।
A2 is by
A2 पेज नंबर माय लॉर्ड 18 A2 है माय लॉर्ड। अपीलेट अथॉरिटी का अगेंस्ट द
ये
ऑर्डर
तो
ऑफ
इसके बाद एक और प्रोसीडिंग है ना, अभी आपके पास ऑल्टरनेट रेमेडी है। सेशंस कोर्ट जाइए, फाइल रिवीजन।
नहीं, सेशंस कोर्ट ये है A4
वो भी हो गया?
हाँ, वो हो गया माय लॉर्ड।
कहाँ है ऑर्डर?
A4 है माय लॉर्ड, A4।
I am asking where is impugned order, you are saying appellate authority.
A4 my lord. It is also A4 my lord, and page number 42 my lord.
Yes.
My lord, para 4 kindly see my lord. पुनरीक्षणकर्ता द्वारा इस आधार पर पुनरीक्षण प्रस्तुत किया गया है कि बालू जिसके परिवहन के लिए जब्त शुदा ट्रैक्टर ट्राली के राजसात की कार्रवाई की गई है, वनोपज की श्रेणी में नहीं आता है। दांडी प्रकरण के निराकरण के पूर्व राजसात की कार्रवाई नहीं की जा सकती। ऐसा कोई प्रमाण नहीं है कि वन क्षेत्र से रेत उत्खनन कर ट्रैक्टर ट्राली से लाया जा रहा था। शौचालय निर्माण हेतु पहले से ही सुग्रीव सिंह के घर के पास बालू डंप था, जहां से सरपंच के आदेश से ट्रैक्टर ट्राली में रेत को लोड कर लाया जा रहा था। वन अधिकारियों द्वारा सूखी बालू नदी से निकाली गई गीली बालू का मिलान नहीं किया गया। बालू के परिवहन में वाहन मालिक के मानवकुलता प्रथम दृष्टया प्रमाणित नहीं है। अतः प्राधिकृत अधिकारियों अपीलीय अधिकारी द्वारा पारित आदेश निरस्त कर ट्रैक्टर ट्राली आवेदक के कब्जे में दिए जाने के निवेदन किया गया है। उक्त के संबंध में पुनरीक्षणकर्ता द्वारा लिखित तर्क भी प्रस्तुत किया गया। पुनरीक्षणकर्ता द्वारा अपने समर्थन में स्टूडेंट्स को केस लाया है मैंने। And thereafter my lord finding of the Leonard
ये तो सोन घड़ियाल एरिया में हो रहा था, रिजर्व सेंटर में।
अभियान में
Then
my lord finding of the Leonard Court below my lord, that is page 44 my lord.
आपका यही ग्राउंड है ना, that it is not in forest offense, और कुछ ग्राउंड तो नहीं है।
नहीं, मेरा ये भी कहना है कि ये फॉरेस्ट एरिया से मैं लाभ ही नहीं रहा था। और ये जो इनका कहना है वो तो हम गांव में सरपंच के
भाई आपको इंस्ट्रूमेंट प्रस्तुत किया गया 1/4/2002
एक जगह से दूसरे जगह में रेत ले जा रहा
ड्यूटी का रेट
था। और इन्होंने इनका कहना है कि नहीं फॉरेस्ट एरिया से लाया था। और
I will not examine the facts. वो तो facts आपके फाइनल हो चुके हैं। There is judgment order by 2 courts that you are doing mining in forest area.
But my lord, this is not forest product, my lord. Only see section 2, my lord, of this Indian Forest Act, my lord.
Yes. Forest Act.
Sand also a forest product.
Yes, my lord.
Let him argue. Yes. Section
2, my lord, of 2 of the forest Indian Forest Act, my lord.
Yes.
वन उपज के अंतर्गत निम्नलिखित वस्तुएं आती हैं, अर्थात इमारती लकड़ी, लकड़ी का कोयला, कुचुक, खैर, लकड़ी का तेल, राल, प्राकृतिक वार्निश, छाल, लाख, सैलाब, गुदवा, महुआ के फूल, महुआ के बीज, कुत और हरडे, भले ही वे वन में पाई या वन से लाई गई हो या नहीं लाई गई हो। और
52 पढ़ी
माय लॉर्ड,
52
52
फॉरेस्ट एक्ट ऑफेंस 52 में है ना।
हाँ, नहीं, इसमें प्रोडक्ट में पढ़ रहा हूँ माय कि जो है रेत जो है ये फॉरेस्ट प्रोडक्ट के अंतर्गत नहीं आती है।
नंबर 35
रेत का कहीं पर उल्लेख नहीं है माय लॉर्ड। और जो रिविजनल कोर्ट ने फाइंडिंग जो दिया तो उसमें पैरा 9 में कहा कि रेत बालू का उल्लेख स्पष्ट रूप से भारतीय वन अधिनियम धारा 2(4) में नहीं है, किंतु रेतीली मिट्टी व्यापक शब्दावली रिवीजन खारिज की गई है।
अकॉर्डिंग टू असेसमेंट वैल्यू एंड मार्केट वैल्यू।
ये फॉरेस्ट प्रोड्यूस के ऊपर फॉरेस्ट ऑफेंस
52
यस
पार्डन मैडम,
ये फॉरेस्ट प्रोड्यूस पढ़ा ना आपने 2 में।
हाँ, इसमें प्रोडक्ट जो भी है उसके ऊपर पढ़ा मैंने।
हाँ, ये ऑफेंस भी पढ़ लीजिए,
7 से
3 भी पढ़
पढ़िए,
लीजिए।
पैरा 8 से पढ़िएगा। प्रतिकूल
वनों को आरक्षित करने की
प्राकृतिक मूल्य क्या होगा,
नहीं
इस संबंध में अनुभागीय अधिकारी पीडब्ल्यूडी की मूल्य के
फॉरेस्ट
संबंध में
ऑफेंस
रिपोर्ट
मींस एन
दिनांक
ऑफेंस पनिशेबल
15
अंडर
1
दिस
23
एक्ट। और बिना
2003 और
परमिशन के
28
जा
12
सकते
में
हैं क्या
काफी अंतर
फॉरेस्ट
है,
के अंदर?
क्योंकि पहली रिपोर्ट में
मेरा
83,550 रुपए और दूसरे में 1,65,700
पकड़ी
रुपए।
गई है और ना ही वो
एवरेज
फॉरेस्ट
निकाल दिया
तो
मुझे
डिफेंस
लगता
हो
है।
चुका है 2 कोर्ट से, वो नहीं देखेंगे कि आपकी फॉरेस्ट प्रोड्यूस अंदर नहीं थी, रिजर्व फॉरेस्ट के अंदर। ये मान के माना जाएगा कि फॉरेस्ट एरिया के अंदर ही आपने अपना ऑफेंस किया है। अब तो आप उसको बताइए, लॉ पॉइंट पे कुछ है तो बताइए, फैक्ट पे नहीं देखेंगे।
निकाल दिया है
पायलट के ये जो जिसको बोल रहे हैं कि फॉरेस्ट प्रोडक्ट है, रेत जो है बालू, और मेरा कहना है कि वो उसके अंतर्गत नहीं
इंश्योरेंस
आती
पॉलिसीज
है।
कहाँ
As per
लिखा है?
section,
पैरा 9
2
पढ़िएगा।
of the Forest
अभिलेख
Act,
से
my lord.
स्पष्ट है कि वर्ष
Yes.
2001 अगस्त 26 का जब
Yes,
जीप
state-
जब्त की गई थी उस समय वर्ष
Sent also a forest
1998 का
product.
मॉडल
Yes.
लिखा हुआ था।
Sent also a forest
अवधेश
product.
मिश्रा के कथन अनुसार
in
उसने यह
Mahendranath
वाहन
versus state of
2,70,000
Assam,
रुपए में
AI
सेकंड हैंड अगस्त
1970
2001 से 2 माह पहले
specially,
क्रय किया था, अर्थात लगभग
जो sand है
3.5
वो
वर्ष
forest
से यह
product
वाहन
है।
वन विभाग के पास जब्त है। 3-4
ऐसा ले
वर्ष
डाउन किया है।
ले डाउन किया था।
के मध्य वेरिफिकेशन के
section में
संबंध में
not silent in that.
न्यू इंडिया इंश्योरेंस
Established
कंपनी
Supreme
की
Court ने
जो
कह दिया, अब क्या
पुनरीक्षणकर्ता ने
करेंगे?
प्रस्तुत की उसमें
नथिंग।
लगभग 40%
My
का
lord, एक तो my lord
डेप्रिसिएशन
is
3 से
not
4 वर्ष में होता है।
Yes,
बीमा
बताइए।
कंपनी ने भी वर्ष 2001
Yeah,
में
having
यह
judgment.
वाहन
मैं
अनुमानित
हाँ पढ़ी।
कीमत
ये
3 लाख
judgment में है
आते हुए
lordship,
बीमा
ये
किया था।
नीचे जो
इसमें 10% के आकलन की स्थिति को देखते हुए 20
है, उसने अपने ऑर्डर में कहा है।
Yes.
2,70,000 रुपए 2001 में मूल्य होना युक्त मूल्य है और 40% के रिन्यूएशन
another
की
judgment
स्थिति को
lordship,
देखते हुए जो राशि 1,60,000 रुपए विभाग के द्वारा
स्टेट
निकाली
ऑफ
गई है
बंगाल
और इस
वर्सेस
स्थिति को देखते हुए
गोपाल
पहले इसका
सरकार
मूल्य 84,500 रुपए
SCC
सक्षम अनुविभागीय अधिकारी द्वारा निकाला गया था। यह
रात्रि में
यदि यह वाहन
खनन
वास्तव में
एवं
नीलाम की
अवैध
प्रक्रिया से
परिवहन
गुजरा जावे तब
अपराध
भी
करना
20%
मध्य प्रदेश
तक कम राशि
परिवहन
स्वीकार
और
करने
वन
का
उपज नियम
1,60,000 में
2006
20% कम कर
16
दिया,
के
क्या गलत
तहत
है?
निषिद्ध है तथा
कहाँ
22
जा
दो
रहे हैं
में
अभी और आप
प्रावधान है कि
इतने साल
सूर्यास्त
बाद
के
क्या
पश्चात
करेंगे?
विधिपूर्ण
गाड़ी है क्या
अधिकारी
अभी?
से
स्टे है क्या
प्रतिरोध की
इसमें?
तैयारी के साथ किया जाता है
अभी तक
जो
तो ऑक्शन होके सब कहानी खत्म हो
अधिरोपित
चुकी
की
होगी,
जाने वाली
इंफ्रास्ट्रक्चर तो
शक्ति
गई
की
होगी।
दुगनी होगी।
That is what I was
28
saying
चार को
कि
issue
फॉरेस्ट
notice,
ऑफेंस तो नहीं
made
है, भले
returnable।
प्रोड्यूस हो
उसके
चाहे ना
बाद
हो,
में
आप फॉरेस्ट ऑफेंस भी कर रहे हैं जाके तो वो कवर होगा इसमें।
In the meanwhile, operation of the order passed by इतना shall remain state. आपने उस गाड़ी का बिल्कुल कचड़ा करा दिया, आज तो कुछ बचा ही नहीं होगा। क्या करना है?
One case now, my lord.
98 की गाड़ी आज 25 साल बाद क्या करेंगे?
तो आपने कौन सा प्रोविजन बताया?
एक तो ये है
सेक्शन
Petitioner
22
has challenged,
Section
petitioner state
22
has challenged order of
of the मध्य प्रदेश
the learned
अभिवहन
second
वनोपज
additional
नियम 2000
session judge Sagar in
फॉरेस्ट प्रोड्यूस
criminal
रूल्स
revision
2000
दे दीजिए,
number
आपको जो लेके
32/2005
इसमें डायरी